I'm making this announcement in compliance with the Open Public Meetings Act, being Chapter 231 Public Law, 1975 laws of the state of New Jersey. The Planning Board Secretary has prepared a schedule of the meeting of the Planning Board of the Borough of Kenilworth for the year 2026 and has posted a true copy of this schedule on the bulletin board located at the front entrance of Borough Hall, and has mailed true copies of this schedule to the local source in the Star Ledger, and is maintaining a copy of this schedule in Borough Hall. Accordingly, the notice requirements of the Open Public Meetings Act have been satisfied in regards to this meeting. Can we stand for the Pledge of Allegiance, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call.
Mr. Paterno?
Here.
Mr. Davis?
Here.
Mr. Clementi? Here. Mr. Paterno?
Mr. Cern.
Oh, I'm sorry. Mr. Cantina? Here. Mr. Maggio?
Here.
Mr. Scuderi?
Here.
And Mr. Ladowdy?
Okay, we're all here. Mr. DeMarco?
Yes, Chair. So I know there's a lot of people here today that don't normally come to planning boards. I just want to explain the parameters of what is happening tonight, what's on our agenda. We do have two resolutions that will be voted on. There is no public comment on those resolutions. They are just a vote. It is not open to the public. There will be no comment for either one of those resolutions. We will then move on to the applications. We have two applications tonight. Those applications, depending on how long they take, could conceivably take all night. What I mean by all night, the board has a tradition and a standing rule that by 10 o'clock we do not take any new witnesses or start any new testimony. Whatever witness is in the middle of testifying, we try to get to a point where that can get concluded, and then we finish the board's business at that time. So for all those that are here for items that are not on the agenda, you may be here for a while. You are asked to respect the fact that there are two applications on here. Although it may not be important to you, it is important to those applicants. It is their houses. They are here to try to get approvals. They have attorneys, they've invested money, they've invested time, and I would ask that we all understand that and allow them to have their case heard by this board.
Thank you, Mr. DeMarco. Communications, is there a motion for approval of the minutes for 4/28/26 and for 5/19/26 special meeting? Motion made by Mr. Mazzio, seconded by Mr. Clemente. All in favor?
Aye.
Okay, resolution application 26002, Core Weave Major Subdivision. Mr. DeMarco?
Yes, there's, before the board is the memorialization of the action that was taken by the board at its April 28th, 2026 meeting. Essentially, it's a resolution granting a major subdivision to Core Weave, Inc. for premises located at 2000 Gallopin Hill Road, designated as Block 181, Lot 1.0102. The applicant appeared before this board on April 28th and provided testimony by their surveyor, Mr. Matthew Sippel. Essentially, he did submit with the application and presented to the board is the major subdivision plan, which was dated originally just December 16, 2025 and revised March 3rd, 2026. The applicant did agree to accept all comments by the board's professionals, namely that of Darren Massey and Malvika Apti, the engineer and planner respectively. Essentially, the existing lot is approximately 35.9 acres and has roughly 1,209 feet of frontage on Gallopin Hill Road. The property is located in the 2000 Gallopin Hill Road development plan, and the property was proposed or is proposed to be divided into 4 separate lots to be identified or proposed to be identified as Block 181, Lot 1.0106, approximately 6.9 acres, Block 181, Lot 1.0105, approximately 13.8 acres, Block 181, Lot 1.0104, approximately 7.1 acres, Block 181, Lot 1.0103, approximately 7.9 acres. The board did take testimony, listened to the public, and various questions were raised. It was acknowledged by the board that they were there for a limited scope of just the subdivision. There was no site plan, no building plans or structures or improvements. And then the board did vote, and at that point in time, it was unanimous.
Thank you, Mr. DeMarco. For the resolution 26-002, is there a motion to approve the resolution? Motion approved by Mr. Ladati, seconded by Mr. Mazzio. Roll call, please.
Mr. David?
Yes.
Mr. Clementi?
Yes.
Mr. Paterno?
Yes.
Mr. Mazzio?
Yes.
Mr. Ladowdy?
Yes.
That's it? That's everyone? Okay. Next application is number 25-007, minor subdivision, Ali Sheikh Enterprises. Mr. DeMarco?
Correct. That resolution is a resolution denying minor subdivision and a variance relief to El Sheikh Enterprises LLC for premises designated as Block 43, Lot 12, known as 530 Monroe Avenue. The matter was heard on January 23rd and March 24th, 2026. The applicant did appear to seek a subdivision and to subdivide the property into 2 lots with a variance pursuant to relating to the premises known as Block 43, Lot 12, as depicted on the tax map of the borough. In particular, the applicant was seeking a subdivision and a variance for the side setback. They did present testimony of their board to the board, land surveyor and engineer Edward Deet. The applicant's architect Roger Winkle also testified. They did agree to accept all of the recommendations by the board professionals. The subject site was identified as Block 43, Lot 12 in the borough's tax records and has a street address as stated as 530 Monroe Avenue. It is a vacant corner lot located at 530 Monroe Avenue between 22nd Street and North 21st Street. The property is in the R5 medium density single-family residential zone, and the applicant is seeking, as stated, a corner lot with a reduced side setback. Various witnesses were testified as to the condition of the lot. On several occasions, the applicant was asked directly by the board if they could make the 2 properties conforming. At both times or on several occasions when asked by the board directly and by professionals, the answer was in the negative, that he did not prefer. He did not even consider it. As a result, the board then took a vote and the application was denied for its variance and subdivision.
Thank you, Mr. DeMarco. Is there a motion to have the denial approved? I guess that's how you would state
You
that,
can
right?
vote yes on the denial.
Would you vote
If you
yes?
deny it, you vote yes.
You vote yes. If you want to
Unfortunately,
vote
that's
yes on a
the-
denial, if it's a denial, vote yes. If not, no. Is there a motion?
I make a motion.
Motion by Mr. Pantina to vote to deny the application.
Aren't you just confusing the resolution? Yeah, it's just a motion to
Oh, yeah,
approve
yeah,
the
yeah, right,
resolution.
A motion to approve the resolution, made by Mr. Pantina, second by Mr. Mazzio, was it?
No, I can't vote on
Oh, you can't, I'm sorry, Mr. Scuderi? Okay, roll call?
Mr. Paterno?
Yes.
Mr. David?
Yes.
Mr. Clementi?
Yes.
Mr. Cantina?
Yes.
Mr. Ladowdy?
Yes.
And Mr. Scuderi?
Yes.
Thank you very much, Mr. DeMarco and board members. Okay, next application is 26001, structure in the rear yard. Diaz is the name, 415 Lafayette Avenue, Block 12, Lot number 9. Mr. DeMarco, as a matter of procedure, do we need to swear in our professionals and any of the witnesses that Mr.
We should do that at this time. Mr. Goodman, I don't know who the witnesses are.
Ed Deck is my engineer, surveyor, and somebody dropped it. You dropped it?
Is it just Mr. Deck?
No, the owner of the property, Mercedes Diaz, is here. She is Portuguese and Brazilian.
We'll deal with her separately. So Mr.
Okay.
Deck, Ms. Ati and Mr. Mazzi, you all please, do you swear the testimony you shall give before this board shall be the truth, the whole truth, and nothing but the truth?
I do.
We'll deal with the applicant, she has an interpreter, so we're
Okay.
swearing both of them.
Okay. Thank you. Good evening, everybody. The applicant, Mercedes Diaz, is the owner of 415 Lafayette Avenue. She's here tonight to ask for C2 variance relief, special reason, to allow for her patio to remain covered. Why is she asking for this? In order to mitigate unique and ongoing impacts caused by the adjoining municipal park and the municipal trees. If Ed Deck could position the easel with the picture. Sometimes a picture tells 1,000 words, and as you can see, the house in question has a covering of the entire patio. It also, you can see the soccer goal that backs up right to her property. There's no netting. And you can
Mr.
also
Goodman,
see...
is there any way that Mr. Deck could clip that up so we could see what's going on? Because we can't see anything from here.
I'm sorry. Perhaps Mr. Deck could hold the picture in front of you so that you would have a good view of it.
Well, it's somewhat better.
Is that better, Mr. Chair?
Yeah, a little better now. You can see, guys? Yeah.
Yeah. Thank you.
So as you can see, that we have the soccer goal right backing up to her property, no netting. There's a lot of playing that goes on. Obviously, that's the purpose of a park. We have two trees that back up right to the back of her property. These are sweet gum trees. There's constant droppings of the spiky balls, obviously the leaves, etc. And so what Ms. Diaz has done, and I certainly on her behalf apologize for not knowing the rules to go and get the proper permits. People who come into our country sometimes just want government to leave us alone. We just do what we have to do to survive. And I think in that case, she does reflect her apology. There was no disrespect in not following the rules to get permits. But there are extraordinary conditions that other residents in the area do not face. The covered deck, which are the covered patio, I believe is a reasonable response to the problems that she had. And so tonight, Mr. Deck will testify to what is there. He is the surveyor, and Ms. Diaz is here to answer any questions through her interpreter, Andrea Torres. So without further ado, I'll ask Mr. Deck to testify as to what this property is like.
Property,
Mr. Deck, if I may, I know that you've been before this board a few times. Are all your credentials still in order and up to date?
yes, they are.
Okay, I find that to be fine with us, everyone here? Okay.
Thank you.
You can proceed, Mr. Deck.
I think all of you should have Mr. Deck's survey, which is dated, I believe, November 7, 2025. And my first question, Ed, is have you been to the property since then? And does the survey that you did in November reflect what's there today?
Yes, I was at the property the night of last month's scheduled meeting, and nothing has changed from what is there presently to what's shown on my plan.
Okay. Could you tell the board what is there now?
The property is situated at the corner of North 16th Street and Lafayette Avenue. There's presently a 2.5-story frame dwelling, and then alongside it, there's sidewalks and a porch, and also a asphalt driveway area for a car. In the rear yard, and that's the area of our presentation tonight, is a gazebo or overhang, a shedded area, which is called a gazebo, and that is a cover, and you can see that on the plan underneath the trees there, right there. And that's over a concrete patio. And immediately to the right of it, as shown on my survey, is a small shed. As you can see, the wall, there's a wall that's shown, represented by a double line that's shown on our property, approximately.
Excuse me, Mr. Deck, the secretary asked if you could just speak up and speak into the mic, because we're having a hard time hearing you and recording the conversation. Thank you, sir.
Sure, sorry.
Is it on?
Yeah. I think so, right? Right. So the area of focus is that area behind the house. It's called the gazebo on my plan, the concrete patio, and it can be also shown or seen on that picture. You also see the white vinyl fence that surrounds the rear of the property. It's mounted on top of that concrete retaining wall, and it butts up against the fence that's on the applicant's property, and that's a fence that belongs to the town, the borough itself. And the two trees are also shown I have a blow-up of this I'd like to pass to the board members. Get it.
Just for the record, Mr. Deck, it's just a blow-up of what was already submitted.
It had an additional shown the trees along the rear of the property, designated on the ground surface.
So we're gonna mark this then as exhibit?
Yes.
Exhibit A?
Yes.
Okay.
Would you mark this, Mr. DeMarco?
Just
Exhibit A?
exhibit A, because it does contain a difference. It has, it's not just a blow-up of what he submitted, it also has the depiction of where the trees are.
Okay, thank you.
As that exhibit A shows, we're showing two trees that butt up against the retaining wall itself. We're very close to it, within a foot.
And does the canopy of the trees hang over Ernest Diaz's property?
Yeah, I would say at least almost half of the tree, of the canopy, extends beyond onto the property.
And when you say they're right up against the fence, how far are the trees from her property, or where the covering for her patio is?
As shown on the handout, I have the trees are approximately, the base or trunk of the tree is approximately a foot away from the property.
And the soccer goal, where is that related
That's
to?
approximately 4 feet away from the property.
Mr. Deck, does the, acting as a surveyor and as a engineer, does the nature of this covering impact at all water runoff and onto the property, any of the neighbors, etc.?
No, the runoff is generated from the rear of the applicant's property. It's not impacting any of the residential properties west of the applicant. If anything, the water would go over the retaining wall onto the adjoining field. It may be an excessive amount because the majority of the property runs out to the north 16th Street
And although it's a corner property, this is the rear of the corner property, so there shouldn't be any impact on traffic or car view, et cetera, because of this rear roof on the patio.
Right, any structures that are located on the property are far enough back from the sight line of Lafayette and 6 inches.
I have no further questions from Mr. Deck, Mr. Chairman.
I was just wondering, Mr. Deck, you referenced the tree and the soccer goal, and it's a foot away from the property. What are you trying to tell the board? That the tree is too close to her property? Or,
I guess the trees impact the applicant's property by not so much the trunk of the tree, but the canopy overhang on their property.
okay, so,
And the soccer ball is in close proximity to her property, and people playing soccer might have kicked the ball over the soccer goal onto her property.
that would exist even if the whole structure wasn't there. If it was just a fence, the ball could still go over the top, right? You live next door to a playground, play area. I mean, that could happen regardless, right? I mean, if that's the point.
If I could suggest, Mr. Chairman, the point that we're trying to make is that if you're sitting on your patio, yes, the ball could go there, but it's not going to hit you in the head if you have a covering. And that's the point that Ms. Myrtis Diaz is trying to make. She just wants to enjoy her property, and she's not telling the town to take the trees down. She's not telling the town to move the soccer goal. All she's saying is, if I'm living there, I just want to be able to enjoy my property.
Thank you.
Mr. Deck, can you enumerate the relief that you're requesting? I don't think I didn't catch it. It's
The
just-
relief that we're asking for?
Yeah,
Yes, the relief we're asking for is there's your land use ordinance permits only a 10 by 10 covering, and her covering is larger than that, covering the entire patio that she's utilizing. So the relief that we're asking for is a larger covering for her patio than the ordinance permits. And also there's a side yard, I believe a side yard shed. No, I believe we're too close.
As far as the different variances,
Yeah.
You have the side yard setback.
Yeah.
So our parameters are a 10 by 10. What is the size?
25 by 30.
so,
Question.
I'll just, I'm not sure if I understand. We can only put a 10 by 10, but if someone came in and requested an addition, there's plenty of coverage on this lot that we could have, it could have been contemplated, no?
You're saying if they,
So the 10 by 10 is what, considered an accessory structure? Is that the
The
issue
rules
here?
for pergola are, I think you have specific rules for pergolas. And I believe it's 10 by 10 is the covering that's.
Because this is considered or classified as a pergola as
I
opposed to...
believe the town has classified that.
Let me ask a question. So, if the property owner came in before she built it, before the property owner built this structure, and asked the board to put up a 10 by 10 structure, it would be permitted, it would be okay. If the property owner came in and asked to put up a 26 and a quarter by, 30-foot structure, the board would listen to testimony and have the option to say sure or no, because it's only 10 by 10 is required or permitted. Yet the property owner did not come to the board, did not go to the town for permits, did not ask for permission, is just asking for forgiveness, I guess, and asking that somewhat of a hardship be asked because it's already up, right? Sounds right?
Well,
And really, the trees and the soccer thing has nothing to do, because the tree
no,
ain't
I think the tree and the soccer field have everything to do with the reason that she's asking for the relief. Putting aside for a second her inability or unwillingness, not really unwillingness, ignorance of not knowing the proper procedure to come before the town. Her reason is to be able to enjoy her property. The trees, I mean, ask yourself, look at the property, if it was your situation, would you like to be sitting on your patio and be bombarded with leaves and bird droppings and sticky balls and potential soccer balls? Or would you take some action to try and safeguard your area so that you could enjoy your backyard?
Would you
That's
also
that
think
not
that,
what-
I'm sorry, Nick, you have the floor, excuse me.
I'm sorry, Chairman. Is that why we have ordinances, though? To maintain certain things? And you, as a lawyer, should know that, and
Okay,
No,
okay,
wait.
so, you're absolutely right. There's
But
no
I didn't
excuse,
finish.
there's no excuse for ignorance of the law. No excuse for ignorance of the law. And I'm here simply to say that Myrtis Diaz does not speak English. She was not familiar with our laws, our ordinances. She did not know the proper procedure. And yes, she's here to ask for forgiveness, not for permission. But it's not out of malice, it's not out of disrespect. It's simply the situation that's before us.
okay, but I thought you should have opened with that rather than trees and buildings.
Yeah, Mr. Ladati?
So who put up the structure? Do we know?
Who built the covering?
Yeah,
Who built the structure?
yeah, I mean,
Nothing.
that's the question, because, I mean, a builder in town should know the law, basically. And we've run it,
Yeah, she was responsible in getting people to build it, yes.
so apparently the builders had no idea
Well,
what the code was. It's just that this happens more frequently than you think. People build a structure, a builder builds something, doesn't do anything correctly, follow the rules, and then the situation comes up more than we'd like, I think.
well, if what you're saying, sir, is that there are many instances similar to ours, I kind
Which
of...
we deny.
Pardon?
Which, okay, again, I'm sorry.
I kind of think our situation is unique simply because we are up against basically the municipal uses that conflict with our enjoyment. And we're not asking the municipality to do anything, we're just trying to make the best use of our property. And I think in that sense, we're different than many of the instances that I think you're referring to.
Mr. Mazzio?
When was this built?
Mr. Goodman, right now you're on the border of testifying, so I don't know if you want to...
Well, you want to swear in these people?
I'm just
Yeah,
saying, you're answering a lot of questions.
Well,
that-
I'm getting the information from them, but let's swear them in so they can answer.
I didn't know if we were going to go one question or 10
Well,
questions.
yeah, let's.
Yeah, I mean,
Swear 'em
I
in.
think it's easier for you, right? Right? It just
Okay, Andrea and
So who's the interpreter first?
Andrea Tucker.
Andrea Torres? Okay. How are you? Good. Good. Do you swear or affirm that the translation you're going to conduct shall be true and accurate to the best of your ability?
Yes, I do.
And then I need you to translate for me. So I didn't say anything, so there's nothing to translate yet. So, hey, Ms. Diaz, do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? And Ms. Torres, just for the record, you're not certified as a translator.
No, I'm
You're a friend.
Yes.
You're going to do the best you can.
Yes.
Okay? If you don't understand something,
Yes.
yep, okay? If you need more time, or you need somebody to repeat a question, all right, I'd rather you get it correct than not.
Yeah.
Okay?
I understand, sure.
All right, thank you.
You.
Can I ask, I'm sorry, I didn't hear your name, the translator?
Andrea Torres,
Andrea Torres. Can I ask you a question?
of
You-
course.
Do you live in town?
No, I live in Newark.
Newark? Okay. How long are you friends with Ms. Diaz?
More than 20 years.
Thank you.
You're welcome.
So, ma'am, if you stand closer, right, because I don't need to hear her answer, I need to hear your translation.
Okay.
Okay?
Yes.
Yeah, Mr. Goodman. I think there, I think.
The last question was, I believe, Andrea, they asked when it was built
And who built it?
and who built it.
Quando foi construído o gazebo e quem construiu para você? August 2025, and was my friend.
Did you say 2025?
Você falou 2025? Agosto de 2025?
And it was her
Yes.
friend?
E foi seu amigo? Yes.
Is he a contractor and does he have a contractor's license?
Ele é contrato, ele faz construção. He's a contractor.
He's a contractor. So he knows the law?
Ele conhece a lei? I don't know.
If he's a contractor, he would know better, right?
Ele trabalha com esse tipo de... He only does decks.
Yes, Mr. Clement.
As far as I was just looking at the report from the zoning officer, notates on October 29th of 2024, the department received a complaint about the property, so it could be 25.
Ok. Eles receberam a informação do Brasil de outubro de 2024.
Quando fez a última etapa.
Oh, because it was done in sections. That was complete.
So at one point, 2024, part of it was
E em 2024 já só foi pequeno, tá? Só estava isso. Yeah, sim.
começou a fazer e ele terminou mais ou menos no final de outubro, porque eu não estava quando eu recebi a unidade, eu tinha.
Mas a pergunta é quando foi construído.
Começou em agosto e foi sempre terminou mais ou menos em outubro.
Mas você está confundindo os anos. Em 2024 já tinha reclamação. The complaint was 2024, correct?
That's what it said October 29th. The department received a
É,
complaint.
outubro de 2029 foi recebido a reclamação. Não, 2024. Oh, she's saying, is it 2 years already?
Porque foi a única pra mim era da
Oh, in her mind, it was 2025.
Okay.
Because it wasn't done like all at once. It was done in sections, and she's kind of confused. Yeah, she's confusing the year.
Okay. So we have a paper in front of us. I believe this was by the applicant who made these statements. In October 29, 2024, the department received a complaint regarding the property. The first notice of violation was sent out to Ms. Diaz, but the property owner did not respond. And if I'm going too fast, slow me down. I'm going to just read the second part, so maybe you could combine it. The second notice was sent out to the property owner along with a summons, and the property owner failed to appear in court. The owner response eventually acknowledged the violation, contacted the office to correct the gazebo and figure out how to proceed. February 28, 2025, the owner filed a zoning application that acknowledged the framed gazebo. (2025) of March, the zoning application was denied, and that's why you're here tonight. So this has been going on since 2024.
In her mind, she thought it was 2025.
I can understand she might be nervous and confused, and we're going to take that into consideration as well. But what the case in front of us here is that you're asking for a hardship, but it's clear that this has been going on for quite some time, and I understand there's a language barrier, and we're sensitive to that. But we also know that the contractor who built this knows better and knew what he was doing. And we also know that when you purchase a house next to a park, you have some things that you have to look the other way with, like a ball coming over the top of the fence. But you also get the beauty of the park. So it's a give and take situation. So it's going to be hard pressed to set a precedent that when a 10 by 10 area is allowed by ordinance, and you build a 36 by 25, you put the board in an awkward position. Because what will happen, I believe, is that everybody in town will start building decks and gazebos and things in the back of their house and come in and ask for forgiveness, so you throw all the ordinances out the window. Pretty much.
When she moved to this town, she moved because it was better for her daughters to go to school here. And she didn't really realize the point of the park. She was like excited about that her daughters was gonna go to a better high school. So she was moving from Newark, and she thought, let me move to a city where the schools are better. I want the best for my daughter. She didn't realize she was gonna have that problems with the park on the side of the house. It's not only like the whole situation, people camp, I don't really have like privacy in I have pictures, people make camp around the fence, so what, okay, você está tentando fazer
Nika? Ms. Andrea?
Yes.
I think the planner would like to ask you a question.
Of course.
Mr. Deck? Okay.
Mr. Deck, just stand in front of the mic. Because you kill me when I have to rewatch it.
Mr. Deck, just for board's understanding, could you recite the variances that you're seeking?
The variance would be the size of the gazebo. We're allowed 10 by 10, we have 25 by, approximately 30 by 25.
I believe the ordinance says 100 square feet, and what's being proposed is 535 square feet.
Correct.
Right, okay. The next one?
The only other one I'm aware of is the side yard setbacks.
I'm referring to our memo by Hyderabad Associates dated May 18, 2026. There are a couple of other variances that you need. One is setback to the gazebo, which is the structure, which is 535 square feet. The rear property line setback required is 10 feet, and what is being proposed is, or what exists is 5.88 feet. Is that correct?
Correct.
The side yard, again, I think our memo, the way it defines what the front yard and side yard is. This property by the park would be the rear property line, and by the side yard street would be the side property line. And the adjacent neighbor would also be the side property line. So that setback is only 5.17 feet. That's also a variance.
That's correct.
In your testimony today, I think what the board heard was the trees are, I forget, how many feet from the fence?
Approximately a foot from the property line.
Probably a foot. And the goal post is about 4 feet from the property line.
From the yes, from the property.
So if this was a complying gazebo, the setback would be almost 14 feet?
10 feet plus those dimensions, that's correct.
Is that correct?
Yep.
So, in terms of the impact from the adjacent park would be minimal if this was a compliant setback.
Well, it would be further away, that's for sure.
Okay, yes. The second question, what's the height of the entire fence, including the wall?
It's a 6-foot high fence, plus the wall is elevated approximately 2 to 3 feet.
So in total, it will probably be 8 to 9 feet?
Probably 8.
Okay. And how much do you think the goalpost height would be?
6.
Okay. Really? It doesn't, in the picture, it doesn't look like it's at 6 feet, but I may be wrong. And there's also a chain link fence in front of it, right?
That's
Right.
correct.
So there are a couple of things that are kind of negating the impact that we've been, at least the board has been told about today in terms of the ball or whoever else is playing over there and the impact that's going to happen on this subject site.
Well,
Excuse me, Mika, is Ms. Diaz okay?
No.
Why don't you give her, can someone give her a seat, please? Why don't you have her take a seat?
Yeah, right here.
Thank you very much for moving over. Ms. Diaz, would you like a bottle of water?
I make a motion that the board take a 5-minute recess.
Made by Mr. Davis, second by Mr. Mazzio. All in favor? Back into session. Motion
So moved.
moved by Mr. David, seconded by Mr. Mazzio. All in favor?
Aye.
Okay. We're back in session. We're sorry that she doesn't feel well. We're going to handle this as best we can. However, there are some questions that I think Mr. Deck and Mr. Goodman can answer without putting Ms. Diaz through that stress. Mr. Ladati?
Yeah, Mr. Beck, you examined the property, so, I mean, this is not just a cover. I mean, I'm looking at what's included under this cover is like almost looks like a stone fireplace, whether it's a stove, a kitchen, grills, and everything else under there. That's what's in there for sure, or, I mean, can you comment on that? Is
Well,
that part of this whole?
I've
It just
been-
seems to me it's more than just a cover to cover trees and a walk on color.
It's considered, I believe, it's called an outdoor kitchen.
Okay?
I have an additional question. So does it looks like I guess it's a stove or
Barbecue fireplace.
extends through the roof. The chimney extends through the roof of this structure. Is that accurate?
That I'm not aware of.
Based on the pictures we're seeing.
Based on the picture, it's accurate.
Okay, thank you.
Mika? I'm sorry, Mika, would you like to have some questions asked?
Thank you, Mr. Chairman. So, I'm sorry for the applicant, but Mr. Deck, just technical questions. So we've established there are setback variances from the rear property line, the side property line, and the size of the gazebo, right?
That's correct.
So 3 variances there. I believe the survey also shows there's a shed on the property.
Correct.
And we noted that, again, the shed is located in the front yard because of the side yards too.
On the street.
That's a variance. I'm not sure if that was ever brought into conformance or ever asked permission for, as well as the setback of the shed from the front property line is only 3 feet. Is that shed to remain?
Yes.
Okay. So you would need variances for that too. So in total, and without talking about the front yard setback, which is an existing non-conformity, the property does need 5 variances with what is existing over there. What is the height of the gazebo?
I never measured it, but it appears it's even with the bottom of the second floor. I would say approximately about 14 feet high.
15 feet high?
14.
I believe,
So the documentation shows that it's 12 feet high, just so you're aware. That was submitted for the hand sketch. And the reason why Mika's asking is 12 feet is the maximum height for a gazebo. So I think that you might want to just refer to the application documentation you put in with it. I don't know, I don't believe it was from your office, but Mr. Goodman might know. There's a hand sketch.
I believe I put in the 12 feet,
Um, I would recommend, if the board was looking at this, that we would need to make sure a licensed architect tells us how to build it, because otherwise, is it a variance or not a variance, it's still up in the air. All right, so we've established, currently there are 5 variances. Mr. Depp, could you, for the board's perspective, provide the positive, and I believe Mr. Goodman said it's a C2 criteria that you're seeking.
Yeah.
Could you please provide the positive and the negative criteria for these variances?
I could certainly comment on that, although I'm not a licensed professional planner. But the positive aspects would be that it lets the applicant enjoy her property to the fullest extent that she's entitled to. It doesn't have any negative impact. There are no residential properties to the rear, which rear that gazebo is abutting. And it's far enough and high enough away to block, most of it blocked, at least the any kind of activity that would be going on there. It's blocked from the street view by the incline and the slope of the property, and also the wall and the fence on top of it. As far as the negative goes, I don't think there's anything negative that's going to impact the neighborhood or the property.
So the testimony that was just provided is the positive impact that it's blocked from the street view. I mean, the testimony was that the height of the fence is approximately 9 feet. Wouldn't that already block everything from the street view?
In other words, people in the street cannot see over the fence.
But it's, the grading of the property is as such that people already cannot see over the fence.
Over the existing fence, that's correct.
Yeah.
Yeah.
So requiring a gazebo that is 500 square feet, where only 100 square feet is permitted, there is an impact on the surrounding neighborhood.
Well, I guess it could be considered a negative impact, only, I think, from someone's opinion that it's intrusive or ugly or doesn't fit into the neighborhood, but it's certainly pretty, from that picture, you really can't tell that there's even a gazebo there. At least I can't when I drive by.
Mr. Chairman, that's all I have.
Mr. Scuderi, thank you. Mika.
I just have 2 questions. One, I'm not sure that you guys can answer. First one is, did she approach the town to put a net, any kind of netting up to block the balls from coming into her yard?
It's my understanding that she has had no conversations with regard to the soccer field. Correct.
And then the second question is, I know we keep saying 535 square feet, but if you look at the measurements, it's more like 800 square feet. Is that?
Well, it's 20, I didn't do the calculations, 30
Six.
feet by approximately 25 feet.
Yeah, so 26 by 30 and change, so more like,
So which is it? Is it?
more like 800 square feet, close to
Right, it would do the math.
780,
6 by 30.
25.
Yeah, 780.
780.
So we went from 100 to 525 to 800?
Yeah.
Is that all you have, Mr. Scuderi?
That's all I have.
Mr. Deck, I'm sorry?
Oh, no.
Oh, I didn't see. Somebody there?
Engineer.
Just have 1 or 2 minor questions I'm not sure if you're going to be able to answer. But obviously, it was brought up by some of the other board members. There's been improvements underneath the gazebo, fireplace. There's been a lot of wiring, lighting, plumbing. Has any of that been designed or checked for code compliance?
Not to my knowledge, no.
Okay. I just mentioned that because with an outdoor stove through a roof, there might be some concern from the fire official for a fire sub-code review.
Is that all you have, Mr. Bass? Mr. Deck, in that picture there, I have a smaller version of it. It looks like to the right of that, that's the small portion of that shed. Is that a shed there? That with that smaller roof?
There's a porch that's right alongside the building, which has a roof.
Then in the next frame, you have 6x6 post with a micro lam beam on top catching the roof. Does that roof structure tie into the house?
From alongside the building, yes. From
So it's part of the house structure now?
Yes, there's a porch that runs alongside the building.
What is it, next to the building?
So where that micro,
A porch that runs alongside the building.
so it's not connected?
I don't
So-
think it's connected with the base.
So what you're saying is that this is like this, and when they come out of that living room door, the rainwater goes into that door, that's not covered in between the two?
I don't think so, but I'd like Mr. Deck doesn't.
Mr. Depp,
If
is
I
that?
can- I haven't seen this picture, so I can take a look. at the
Somebody provided it
I
to
provided,
us.
yeah.
Okay. But there's every picture but that picture. Like showing what's beyond the microlam beam, which looks like maybe a 2-foot opening or so before you get to the brick wall of the house.
Talking about this.
And I can't imagine that when it rains with that pitch roof, that water's diving right into the house. So my question goes to, is the roof structure part of the house?
The roof structure of the gazebo,
Mr. Depp, take a look at that picture, and you'll see the fireplace, you'll see what looks like a bar, and it's sliding doors. And then you got a microlam beam that goes right across here. So the roof structure goes down like this, the microlam beam is here, the doors are here. You're telling me it stops here and doesn't tie into the house, and all that rainwater, with all of that beautiful work?
well, there appears to be something there, I can't tell from this picture, but I would think that they would have that covered between the edge of the gazebo and the house itself. I don't know if it's an eave from the house that extends to the gazebo, I don't know.
Well, something's going on. Something's going on. Because you wouldn't build this structure and have that drop off of water coming into that, let's look at what it is.
On a drive-by, it was my impression it wasn't.
I looked too, I drove past.
At
it.
first blush, it's not connected.
I'm just wondering if they were gonna put gutters up or something, but it's not finished. They kinda just stopped working.
You know, in this look, it looks like you can see daylight coming through. The reason I'm saying that is because once it's connected to the house, it's another whole issue.
I did drive past too, and I didn't think it was connected, but I wasn't looking specifically to that. There's nothing on Google Maps. Looking aside, it's not there.
Mr. Chair,
Yes.
the other issue is, the planner brought up that the height limitation is 12 feet, otherwise you need a variance. And I'm a little concerned because we don't know what the exact height is at this point. It's not been projected. I appreciate Mr. Goodman saying that it's 12 feet, but I don't think he went out and measured it, or there's no evidence of anybody measuring it, so it's unclear whether a variance is needed for that also. So a better course of action may be to carry this, to allow them to answer some of those questions of, is the building actually attached? You know, is there a need for a variance for that? That may also give an opportunity for the applicant to recover and provide any testimony if needed, because she was not able to finish her testimony. I just put that out there that I'm a little concerned that there may be a unknown variance that we don't decide, and by implication, some of the things we do approve it, because there's really nothing in front of you to say that it is actually 12 feet.
I mean, I don't mean to be rude or disrespectful, but I'm a little surprised, Mr. Deck, that you haven't provided the details around the structure that we're here to either approve or deny this evening. I mean, usually you present the variance relief that's required, things of that nature, which you have not done tonight. So I think I would agree with the attorney that we should carry this case, that you should get your ducks in a row, so to speak, and then come back with the information that's required so that the board has all the facts at hand.
And it may also need to be renoticed, depending upon what the written notice had, with regards to the variances. I know there's a like to put in the catch-all, but when you go from 1 to 5, or maybe 6, better course of action might be to renotice that carry here.
Yeah, the board would absolutely recommend that this is renoticed. Get all your ducks in a row. I think the board is in agreement with carrying this.
Mr. Chairman, just one
Sorry.
question.
Yes, sir.
So if there's people here for or against this, could we hear that tonight, or should we wait till we hear the,
If it's being carried, you have to wait until
okay, that's,
I mean,
so,
if there was somebody here that had a question for Mr. Deck on his testimony,
up to now.
up to now, I would
Okay.
prefer, because it's fresh for the board and fresh for that person, and they might not be able to come
Okay.
that day.
So if that is the case, then if this part of the testimony is over, Mr. Goodman, then we would have to open it up to the public to,
questions.
or for questions about this
we're
application.
waiting to this application.
To his testimony.
Would you like to do that at this point?
Yes.
Okay.
So is there, sorry, is there anyone from the public that wishes to ask any questions of Mr. Deck related to his testimony so far with regards to this application?
Seeing none? Okay.
I make a motion that we carry the case. I guess it would have to be to our September meeting at this point.
Right now, it's in September, based on our summer schedule and quorum, but we'll let you know when.
Sorry. I would prefer if we just said it's a September meeting so we can notice it, and if we don't get to it, we can always carry it
There you
without
go.
notice at that point.
We know the date.
September 22nd.
September 22nd.
Okay.
All right?
Motion made by,
Thank you, Mr. Goodman.
Thank you.
well, we got to close it out, right? The motion made by Mr. David, seconded by Mr. Mazzio. All in favor?
Aye.
Thank you, Mr. Goodman.
Man. Let us just get organized here a second, gentlemen. Give me 1 minute, okay? Yeah, right.
No, not yet.
Okay. Our,
We do have an easel with plans, I don't know if you want to bring that up.
okay, our next application is 25001, one family to two family. Hamadi Asi, did I pronounce that correctly? 214 North 15th Street, Block 32, Lot number 5. Who do we have in front of us tonight?
Perfect, thank you, Chairman. My name is Christopher Rodriguez. I'm counsel for the applicants Ayat Ghazi, Abtessim Abunaga, and Hamdi Ghazi from R&R Legal Advisors LLC, 28 Valley Road, Suite 1, Montclair, New Jersey. We're here before the board today with respect to that property located at 214 North 15th Street, Block 32, Lot 4, Zone R5A. We're seeking a C2 hardship variance. The purpose of this particular application is to allow a family to stay together, essentially. The current owners, well, two of the current owners, Abtessim and Hamdi, are getting older in age, and they'd like to have their children. So Ayat Ghazi, who's their daughter, to move in an upstairs unit. So this is a conversion from a single family to a two family. And we are seeking C2 hardship variance relief, specifically from the minimum lot size requirement of 7,500 square feet, which was amended back in 2015, which I think some of the board may remember, as well as the parking requirement, which would mandate that we have 4 spaces, the turnaround requirement for the driveway, and specifically with respect to the tandem parkings, I know the plans currently have a 4 parking tandem setup. The applicant advised me that that they're going to be walking away from that setup, so they convert that into 2. So I don't know if as a condition for approval, we'd submit revised plans to show that it's a 2 parking space in the back, and we'd be seeking a variance for 2 spaces to meet the requirements. There's also a pre-existing front yard setback condition, which is not being touched whatsoever. The front yard is not being changed in any form or fashion. And we are seeking a waiver with respect to the driveway width. The bulk of the driveway is 12 feet. There's an abutment with respect to some stairs that lead up to what would be the second floor unit for a small portion which the architect will testify to later today. There is a small section of 10.8 feet on that driveway, which we'd seek a waiver for because it would not restrict a car to go back into the rear side of the parking lot. There's also some notes from the planner's report and the engineer's report with respect to buffering requirements and water table requirements. While we don't have those today, we will comply with those items as a condition on approval. So in furtherance Also, there was one suggestion from, I believe, the planner's report requesting that we seek approval from the Union County Planning Board. I don't necessarily believe that that's necessary, since the road that the property's on is not a county road. But in further into the application, you'll also be hearing from our architect, Mr. Anwar Al-Khatib of AK Architecture, and our planner, Mr. Ricardo Fernandez of Jaya Consulting. The architect will be testifying as to the floor layouts, and specifically shall respond to items raised by the town planner and engineer, specifically with respect to the water table, basement exit, attic space, the driveway width, and Mr. Fernandez will be testifying as to the parking variance and the statutory positive and negative criteria mandated by municipal land use law. So without further ado, I'd like to call our architect, Mr. Anwar Al-Khatib.
Good evening, everyone.
Good evening, Mr. Could you spell your last name, please?
Al-Khatib. Yeah, you can just say A-L-K-H-A-T-I-B, but you can say just Al-Khatib.
Have you appeared before this board before, sir?
No, this is the first time for me here in this board.
Okay, can you just give us your credentials, and is your license still in order?
Yes, I'm a registered architect in the state of New Jersey. My license is current. I testify in different boards in the state of New Jersey, in Jersey City, Paramus, Clifton, and this is the first time testifying this board.
Okay, thank you, sir.
Mr. Al-Khatib, can you just, do you swear or affirm that the testimony you're about to give to the board shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
You guys have the microphone? No? I want to be by the board, so if I can see that.
Yeah, as long as the board can hear, would it be okay if he approaches?
There's a microphone.
Ah, okay, perfect. Okay, Mr. Al-Khatib, as just a matter of knowledge and to educate the board, could you walk through some of the design elements that you've crafted into this particular set of plans with respect to each floor's layout?
Yes. So I will start, just going over my plan so I can explain exactly what we did as a project. So, sorry. So, first of all, this set of drawings here are the same set of drawings that you guys have, and they are dated the same date. No changes. No changes on it. So the same number of sheets and the same day, which is the last day was March 11, 2026. So I want to skip the first page, which shows the location of the building, zoning map, and tax map. Go over the site plan. So the existing property is 50 by 100. Right now contains a single family home occupied by the owner. Has 1.5 floors. The first floor is used for living space, and the second floor is used for bedrooms. And the existing building is located about 21 foot from the street line. So there are some non-conforming conditions in this property. Should I go through it right now?
Yes, Mr. Al-Khatib.
Okay, so first we explain about the lot. It's 5,000 square feet, which is not existing non-conforming condition. Minimum requires 7,500 square feet. The lot width as required is 50 feet, and we have 50 feet, so that's conforming. The front setback requires 25 feet. The existing building is located at 23.1. The proposed construction and alteration of this property will not change the existing front yard. So the proposed front yard will remain as 23.1, which is existing non-conformance. The rear setback requires 20 feet, but right now we have 52.6. We are doing an addition that will, set back about 28.8 feet from the rear yard, it's still in compliance. The total setbacks of the property will be 20% of the width. So the required will be about 10 feet. We have 19.6, and the proposed is still 19.6. Our addition will be explained later that it's only being added to the rear. We're not introducing any side yard additions. The maximum height is 2.5 floors permitted. We have right now 1.5, and we're proposing 2.5. The building height permitted as a foot is 35 feet. Right now we have 27.75. We're proposing to have 34.8. so we're like shy from the maximum. The maximum building coverage is 50% is permitted. Currently we have 18.4, we're proposing 29.4, which is also permitted. The maximum impervious is 75% maximum allowed. We have 36.3, we're proposing up to 74.3, we're still under the maximum. And the floor area ratio, 0.75, right now we have a 0.27, and we're proposing 0.727, so it's still within the requirements. The parking, we're proposing to have, in our plans right now, we're showing 4 parking spaces, which is 2 tandem. We're eliminating the tandem parking spaces to meet the tandem variance, and the planner will go over this change in the variance. So that variance will be removed as tandem, but will still remain as required parking. So what we're proposing to do is to add to the existing building, to the rear yard, about 750 square feet of building area with a basement, first floor and second floor. And also we are creating an attic to be connected to the second floor. What we're trying to do also, in addition to the addition itself, we are trying to convert the existing single family to a 2-family structure. Since right now the building is located on the zone R5A, which permits a 2-family zone. So we're trying to bring this building to match the existing zoning used in this area and to bring the 2-family building. So I want to move right now to the existing condition of the building, so we can show what we have so far. So as mentioned earlier, right now we have only 1.5-story building. I'm going to drawing 8-01, which is the demolition plan. So in that sheet, we're showing the existing conditions of the building, also some photos of the existing structure, and from the existing survey as well. So the existing building right now, an existing basement with a 7-foot height, right now is used basically as a finished area with some sitting area with a full bathroom and mechanical areas. Existing first floor, we have right now 1 bedroom, living and dining area with enclosed porch. The height of the existing first floor is about like less than 8 feet, like shy of 8 foot. And the existing second floor, you can say is a half floor because it's more as a Cape Cod condition, which is an attic with 2 bedrooms. They're not full height, so you will see from the elevation they are like basically it's like the roof of the first floor with the bedrooms inside between 2. So the existing condition of the house are not meeting the standard, the modern quality lab that we have right now in New Jersey. And the client, our client, and the owner wants to improve that building itself. So he said, I want to improve it, and also I want to add to it to bring it to a 3-family condition, to match the property, and also improve the quality of the building. So what we did is we added to the rear portion of the existing house 750 square feet of building area, which will include finished basement, and we added first floor and the second floor. The first floor, we altered the interior of the first floor. Sorry, this is drawing 8-02 for the proposed floor plans. The proposed first floor was altered completely to change it from living and dining kitchen into an apartment. So the apartment would be apartment number 1, and would have 3 bedrooms, 2 bathrooms and a half, and a kitchen. This first floor would be directly connected to the existing basement. So the basement, the first floor would act as 1 unit. And the access from the stair from the first floor to the basement will be only restricted to the first floor. And also there's an exterior exit from the basement to the rear yard, also to be used by the first floor. The second floor, which is the new floor added to the building, plus the addition on the rear, will create the second apartment that will be introduced into this project. The second apartment will be very much similar to the first floor apartment, 3 bedrooms, 2.5 bathrooms, kitchen and living and dining area. Now the second floor, it has an access stair connecting to the attic created by the roof line that we have. That attic would be a finished attic with the maximum allowed permitted by the zoning ordinance to be used as an accessory to the second floor. So
With Mr. Al-Khatib, before we move forward, there were a couple of points that I believe the planner had in their report. With respect to the rear entrance for the basement, what's your understanding of the purpose and use of that particular rear entrance and whether that's necessary to this application?
Well, the rear end of the existing building can be used for the, whoever is using the recreation area in the basement to access the rear yard. So for convenience purposes, so it will be all easier to access the rear yard from the basement instead of going through the basement, through the stair itself, walking through the driveway, will be an access driveway for the parking space, and access the rear yard. So that's the only purpose for the rear yard. We have a full bathroom in the basement, we don't have any kitchen line, and we are, open to any conditions requirements for the basement to be used as a building permit.
Perfect, thank you. And as to the attic space, do you have an understanding of what the use of the attic space is intended for?
So the attic space I was explaining earlier is connected to the second floor apartment for the stair itself. So we're going to drawing A-03. We have about 600 square feet of an area of the attic. The usable area is only 489 square feet, which has more than 500 height. And that portion of the attic will be an open space connected directly to the second floor, strictly used by the second floor itself. There's no other stairs, and will be used as a recreation sitting area for the whoever using the second floor with a bubble. So it's strictly used by the second floor, and also we have 2 windows, front and back, giving lighting to the attic itself. So looking at the building section that we have in this drawing to show the actual roof line created in the attic and which is finished. Going to drawing A-04, which is the proposed elevation. So the building's architecture will be blending with the existing neighborhood. Typical two-family with standard pitched roof, siding, asphalt roof shingles, double front windows, very much similar to the neighborhood. Not bringing anything new to the mix that we have there. There will be permitted height 34.5, maximum height 2.5 stories, and a basement. We have vinyl siding in the front with double front windows, probably white color. Then we have also a stone covering the basement, exposure of the foundation board themselves, and then we have the name of the building itself matching in color. And that's basically what we have in the architectural requirements.
Perfect. Mr. Al-Khatib, could you actually go to the driveway section real briefly?
No, I didn't. Okay, so the driveway. Yes. So we have right now an existing driveway is about 13'8", which is used right now currently for parking and access to the rear yard, which also has existing parking for the existing structure. What we're trying to do is keep the existing driveway to extend the parking itself to the rear yard and provide 2 parking spaces on the rear of the car. One of the comments that we have about the width of the driveway itself, it was, reduced by about 3 feet in the location where we have the stair to access the second floor. So if I go to the architectural floor plan, we use that for the projection of the stair to access the first, because the first floor is higher than the grade about 3 feet. So we have to access the stair. So that projection of the stair and the line creating that width variance that make the driveway itself is the 12 feet.
And based on your knowledge, I believe that the width is reduced from 12 feet to 10.8 feet, is that correct?
Correct.
And based on your expertise, can a car still pass through that area?
Yeah, it would be passing. Anyway, we don't have the 2-way driveway right now. It will be 1-way driveway. So somebody who comes on, we have to wait for them to leave. So the 10-foot versus 12 feet, from my experience, it works just for the pass-through. And only just passing through the landing and a couple of steps. It's not the whole length of the driveway itself.
Perfect. Okay. So there were also a couple of comments with respect to buffering requirements with respect to the commercial structure that's nearby, which is the baseball field, and the HVAC.
Yes, we will comply with the buffering either in terms of landscape or maybe like some kind of fencing. Whatever, it's in work with the buffering beyond this, the city plan will work with it. So we don't have any issue with that.
And do you have any concern over the seasonal high water table with respect to subsurface floor elevations and whether we can comply with those particular requirements?
we'll comply with that. The new addition is that has a basement, so if we will do the geotech report, if we see any issues with the water table that we need to raise the basement itself, we will raise it just to comply with the requirements, and if it has to be, we can go a little bit lower, we'll go lower. So we don't have the geotech report yet now because we're not in the construction phase, but we will share a copy of that with the building department, and we'll see if we can comply with the 2 feet and or we do some modification to the proposal.
Perfect, thank you, Mr. Al-Khatib. I have no further questions for our architect, so board, if you have any particular questions?
I think the board is going to yield right now to the engineer and the planner for questions and comments.
So, my first question would be, obviously the tandem parking is going to wait for the testimony. Is it still intended to have 2 spaces to the left of the driveway still, or is it going to be just a straight in and out driveway?
Oh, it will still have the 2 spaces, but Mr. Al-Khatib, if you want to
Yes,
answer that question
so-
in more detail. And also the planner will be speaking to those points as well.
Okay. That was one.
Yeah, so the 2 9-foot and 9-foot spaces will be still, the one at the end, they will remain, but the 2 10 will be completely eliminated. So the car can back up and we have a backup condition, so they can move out the driveway.
So we'd be seeking a variance of 2 spaces.
Now, my next question would be, with the basement access, just looking at the floor layout plan, I know that it's proposed as a finished basement, but with a full bathroom and shower in there, what's going to prevent that from being converted into another unit with its own entrance?
Well, first, we don't have any kitchen or gas equipment there, so that one is the condition. Second, we can just, work with any condition we have in the resolution. We can have a deed restriction or whatever is needed to be done there. Also, we open the installation, it's easier for us to make it work.
The applicant is definitely amenable to any suggestions of the board.
Yep, the concern would be because if that were to ever get converted, obviously it's going to be a larger parking variance and issue. We don't want to have, something that where there's proposed 4 required, and now it gets to 5 or 6 because of that. So that's why I just want to make sure the record's clear. Obviously, you said you will, I'm assuming you're going to comply with all the letters, because right now we're going to need a full final grading plan to make sure that there's no adverse effects to the neighboring properties. So that would be something that we would require if this were to be approved as a condition of the approval. The upstairs attic space, is that bathroom that's in there, is it a full or half bathroom? Just for
It's a half
clarification.
bath.
Thank you, Mr. Chairman. Would you please let us know what's the square footage of each unit?
Yes. So the 2 units will be identical as a living area was area. So we have about 1,300 square feet. 1,300. Second floor will be about total 1,470 square feet, and the first floor 1,470 square feet. Now, if you add the attic to the second floor, which is with a large square footage of unit, will be about like 2,000 square feet. The second,
What about the basement?
and the if you add the basement to the first floor would be, multiplies would be another 2,800 square feet.
So just so I get it right, your first floor unit is 2,800 square feet?
Including the basement.
Yeah, that's part of the unit,
Correct,
right?
yes.
And it is finished, so it is a usable,
Correct, yes.
habitable space. And the second floor unit would be 2,000 square feet, which includes the recreation space in the attic.
Correct.
Is it still your testimony that it's still just going to be 3 bedrooms per unit?
Yes.
I think as board engineers expressed concern, as professionals, I just want the board to know we are a bit concerned about that exterior exit from the basement that can have likelihood of getting converted. Not from this applicant, but in future it might happen. It's a convenient shift. So I would recommend to the board to consider some kind of conditions to prohibit that. And as you've testified, the applicant is amenable to
Correct, yes.
something to that effect. In terms of, I know the testimony is that you'll meet the HVAC ground buffering. I just want to make sure the understanding is there that it would require a minimum of 3-foot wide area surrounding the ground-mounted HVAC. It's your understanding that that area exists and that you'll be able to comply with it?
So it's clear around it or as a height?
No, it's basically, it says buffering shall consist a minimum of 3-foot wide area surrounding all sides of HVAC and utility boxes, and screening shall be at least 4 foot high.
Yes, yeah, we can comply with that. We will adjust it because right now in the area we have extra space, and between the backyard to the proposed stair, we have more than 7 feet, so we can do that.
Okay. And then the second testimony was again regarding the buffer, that you will comply. I want to make sure, again for the record, the buffer width has to be 10 feet and the screening height has to be 6 feet. You
So
do have space for that.
When you say the buffer for the 10 feet is like away from the property line or the itself?
So it's counted from the property line where you are adjacent to commercial or a non-residential property. From there, it has to be a 10-foot width, and some kind of screening has to be proposed, which can be up to 6 feet high.
Buffering from the neighborhood and from the property lines, yes, we do.
So you do have it.
Yes.
All right. Just want to make sure those exist. In terms of just because you are an architect, I want to make sure the size of the unit, are these the general sizes, 2,800 and 2,000 square feet for a 3-bedroom, or is it a slightly larger units?
These are a little bit more quality life of typical 3-bedroom units. You know, if you go to a typical apartments for 3 bedrooms, they do like 1,200 square feet, maybe 1,400 square feet. But because we're trying to get like better quality, and we're including basically as a duplex condition, because they have basement, and first floor, and have second floor, and attic. So that square footage, I think it's very applicable to quality housing right now in this case. So it's not that too big if you divide it into 2 floors. If it was 1 floor as a 200,000 square feet, yes, it would be there.
Just so you understand where I'm coming from, in this zone, a single family is allowed to have a 5,000 square feet lot area, and 2-family requires a 7,500 square feet area. The ordinance was established keeping in mind the unit sizes that would be reflective of the size of the unit that comes there.
Correct.
So,
I understand, but also our FAR is within the limits. So we try to take advantage of FAR that we didn't pass it. So that gave us more privilege to have more square footage, which is better for quality, since we're not, against any of the permitted ordinance.
And I do believe that the planner will be testifying further as to the characteristics of the neighborhood. You'll find that there are a number of 2-family lots in that area that are sub 7,500 square feet, all actually fairly spot on to 5,000 square feet.
thank you, Mr. Chairman.
Thank you.
Applicant will now call the planner, assuming there's no further questions.
Excuse me, does the board want to ask any questions now, or you want to wait for the planner and then we could? Okay.
Thank you, Chairman. So the applicant now calls Mr. Ricardo Fernandez.
Good evening, Chairman, board members. My name is Ricardo Fernandez. I'm a professional planner in the state of New Jersey. I've been doing this for quite some time and have testified through many boards. I've never had the pleasure to come before you this evening, so I'm very happy to be here. I'm a licensed planner. My license is still active. I have an undergraduate degree in urban studies and a graduate degree in community development, and I've done this for applicants and for municipalities alike.
It's fine. Thank you very much.
Mr. Fernandez, if I may, do you swear or affirm the testimony you're about to give to this board shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
If I could, I
Just want to make sure they recognize you.
Oh, I'm sorry.
I'm sorry.
I didn't know if you accepted this offer.
Yes, I did. We did,
Okay.
yes. Before you swore him in.
I want to make sure.
So what I did is I did a little slide deck show for the members just to ease and make it faster. If that's okay, I'd like to put that into evidence if that's okay.
Is this new?
It is
Okay.
new.
So,
It did use a lot of what you already seen before you,
Okay.
but that way we can just follow along and make it easier.
so this council is to be marked.
Exhibit A.
Exhibit A1.
Thank you, Council. Ooh.
That's ridiculous. Need a little rubber surface.
It's got a bit of a gavel effect to it.
So I prepared this for this evening for the board members. The first is just indicating the address that we'll be presenting. The second page is the zone map, so we know this is in the R5A high-density 1 and 2 family zone. I also tried to take from existing exhibits to make part of this so that there's no new photographs. So this is actually from the planner's report showing the subject property and the neighboring properties. As you can see, I'd like to draw your attention to the property that is directly next door to this parcel, so you can see kind of how that sizes up in comparison to the applicant, as well as the three properties across the street, starting with the reddish-orange roofing going up north towards the top of the page. The next page, not to belabor the point, is our zoning requirements and the waivers and variances that we're requesting. As was discussed, there was a 2015 ordinance change making two families from a 5,000 square foot to a 7,000 square foot, 7,500 square foot lot. There is a pre-existing front yard setback that, irrespective of the board's action this evening, that's to remain, which is 23.1 and 25 is required. We are requesting, at the bottom I highlighted it, even though it says it complies, we agree with the board professionals' reports about the tandem parking and the backing up radius. The good news is that under its current condition, the vehicles have to back out, and under this new condition, based on the ordinance requirements, you're able to do a K-turn once we remove those tandem parking, and you can come out straightforward and not need to back out onto the roadway, which I know was a requirement of the code. The next one is the existing survey of the existing conditions.
Just so we're clear, you're on page 3, top slide, right? It's the way you handed it out.
Oh, I'm sorry, yes. I'm going too fast?
No, you keep saying next page, but I didn't turn the page.
My eyes aren't what they used to. I keep putzing around with my glasses, and I keep forgetting when to put them on and take them off. So I made it bigger for my eyes, but I didn't want to waste too much paper for the board members. Yes, so it is the top of the third page. These are the existing conditions. So what I just mentioned about the driveway, if you see the driveway right now, you come in head on, and then you have to back out. With the new design, you're going to be able to do the K-turn. So the next slide, which is existing conditions underneath, this just kind of solidifies the discussion about the substandard condition of the property. As the architect was going through the existing conditions of the second floor bedroom, my head started to hurt because I started to remember my first house. That's how it was, and I kept banging my head off the side of the ceiling because the roof was hitting the bedroom. So obviously, in comparison, when you look at this photograph and you look at the rest of the neighborhood, this is actually incompatible with the neighborhood. It's much more substandard than the other properties that are there. It would be the fourth page on the top. It says properties across the street from the subject property. These are the three parcels that we indicated from the planner's report. These are all two-family houses, existing two-family houses, on similar lot sizes that currently exist within that section of the neighborhood. Now, just to refresh the board's recollection, because I know you know the township much better than I do, this is a dead-end street, and the neighboring property to the right of this parcel is the Little League field, right? It's the Kenilworth Little League field. And then the bottom slide is the property directly next door. That is also a two-family house on the same exact lot size. When you compare the slide on the previous page of existing conditions I know it's going to be a little bit hard to see, but if you look at the first picture to the left, right, of the 3 pictures that are on existing conditions, I purposefully took that photo so that the board members can actually see the setback, the rear yard setback that the neighboring property that is a 2-family has. So when you're talking about the footprint, you'll see that the footprint that we are proposing is going to be consistent with that next door neighbor's footprint and their rear yard setback. So just so, and if the picture is too small, I actually made a larger copy that we can add into evidence just so that it's more visible. I mean, I could do that if the board would like.
I'd like to see that, please.
We'll mark that as A2. So, and just for the record, you took these photos?
I took these photos. I'm the one that put them in the PowerPoint.
When did you take the photos?
I took the photos on Thursday last week.
Okay.
So the photo that I'd like to draw your attention to is the photo on the upper left-hand side of the photograph. Whatever you want to mark it and pass it down. You'll see that the rear, where the property owner, the subject property ends, the neighboring property has a good additional other like 15, 20 feet of setback still within that property line. On the 5th page, you have the proposed project, which the architect went over. I won't belabor that point as well. It's going to be consistent with the neighborhood. It's going to have siding that's consistent with other properties in the neighborhood. And then finally, the proposed project, which is also part of the architect's plans, which shows the parking layout that we will be removing the 2 parking spaces. So, to sum it up, the use is permitted. It's not uncommon when a municipality changes a zone that there are pockets of neighborhoods and blocks that really are pre-existing non-conforming now due to that change. And in this particular case, there's very few of them that are actually single family on the block, right? So what happened in this instance is those that had the opportunity to do it before the ordinance change were able to do it and get it. So literally, if we were here before you, before that ordinance change, we'd be in compliance with just about almost every single bulk requirement that the municipality had at the time. Unfortunately, things being what they were, our client was unable to do that. Just to paint a little bit different picture and understanding as someone who's represented municipalities that have had major issues with illegal housing, right? They have, right now, the parents are elderly and they needed to live on the first floor. 2 of their children are set to live on the 2nd floor, and they're sort of caretakers to them on the 1st floor. But they are blessed with 2 more children and 7 grandchildren. So the idea was, well, if we get the kids running in and out of the house, right, how can I let them use the yard without kind of running through the, so that was the thought. But again, as was stated, they're amenable if the board were to say, okay, close that staircase, they'd be happy to store the staircase. Just wanted to give you kind of an understanding why they wanted to have as much usable space as possible within the unit. Just so I can read it myself. The front yard setback that we're requesting is a pre-existing non-conforming. That will not change. I believe that the benefits of updating this property, bringing it into conformance with today's standards, as well as making it consistent with the neighbors, definitely outweigh any of the detriment that you may have, especially that this is going to be kind of the benefit of one family as a whole. As you can see, especially with the removal of the driveway tandem parking, The driveway is actually going to work better than it currently does, where they're able to do a K-turn out of the property and come straight out. I do believe as well, in my professional opinion, that a 10-foot driveway width, especially for such a limited portion of the driveway, right, does not interfere with the K-turn, so they're going to be able to do the K-turn, and it allows enough room for a vehicle to get out past that small stoop that they have there. The project, I believe, also in the update meets the purpose C of the municipal land use law, providing adequate light, air, and open space. It also promotes, under purpose I, a desirable visual environment through creative development techniques, especially bringing it up to today's construction standards. The project is not only within character of the neighborhood, it's actually more in character with the neighborhood than what's currently there as it sits today. And you've heard my testimony, you've heard the architect's testimony. You can actually see on the first page of the plans before you kind of the tax map layout. All those two-family houses are on identical lot sizes as the applicant. The one anomaly is the one that's closest to the corner, and I believe that was recently approved because they had multiple lots they were able to adjoin. Our client has asked the municipality to try to get a portion of the park, but I don't know about you, I don't want to cut center field any more than we have already cut it because they're hitting enough home runs over the fence as it is. And as far as the parking standard is concerned, that whole section, it's a park. And that's not the main entrance to the park. The main entrance to the park is on the other side and has its own parking standard. Its own parking lot on the main thoroughfare on the other side of the ball field. So this is not the main entrance. We believe that most of the time there's going to be more than abundance parking on-street parking abutting that ball field, because there's at least several hundred feet of length going down that, I think it was the left field line, that, isn't with another use that would require the parking for that section. So when you're talking about two cars, I think that there's more than enough space there to accommodate those two cars, especially during, the non-working hours. And that is my testimony. Open any questions that you may have.
Thank you for your testimony, Mr. Fernandez. The engineer have some questions?
Yes, just for clarity on the site, on the cover sheet, I know you've mentioned in the neighborhood there are existing two families. Can you just identify what block and lot just so it's clear to the board?
Sure. So, just for the board's edification, that goes along with the photographs that I took of the neighboring properties. The one directly across the street, in fact, if you look at the one that is to the left of the property, you can see that it's almost the identical lot size. And then when you look across the street, not with the exception of the two larger lots, the four lots next to it are identical lot sizes, and the photographs are there showing the two mailboxes, showing that there are two family properties. We looked at the tax map. There's at least 5 of those properties that are here that we can identify as two families through the photographs. So just read the block numbers. I gotta get my glasses on that. I got a little tight on that. Give me a second.
All right, so lot 6, lot 5, lot 4, lot 3, lot 6, and lot 6. So
On block 32. So lot 33, we're talking about lot 6. So the photos you have specifically show lot 3, lot 4, and lot 5. Because lot 6 is almost off the 200, but that is also, and if you notice there's like a guardrail that divides the street. So that last one is also a two-family, but it was kind of a little bit off. But there, you see they're all identical lot sizes. And then on the block across the street is block 32. That's lot 6. Not to mention that, lot 7.01 is also, but it was a different design and it seemed larger than our lot. That's a two-family, and the one across the street is a two-family on the corner as well. So as you can see, with the exclusion of our property, You're lucky if you have one other one that's a one-family.
Mr. Fernandez, I think you did a thorough job with respect to summarizing the criteria, but if you could just provide a quick bullet point as to the positive and negative criteria, just for the sake of the board and for the planner.
Yeah, so the positives of renovating and, rehabilitating an outdated parcel, right? Bringing it up to today's standards, bringing up energy efficiency, which doesn't only help their bill, it also helps the neighbors when they're using less of the resources within the neighborhood. You also have the fact that you're helping a family, an elderly family, have access to a more modern style home. The positive outweigh the negative of, I believe, in my professional opinion, that it does that. It forwards the purposes of the intent of the plan. And if it were not for that change in 2015, again, understanding that I understand completely, the board had a purpose, the municipality had a purpose, but this is a unique case, right? It's a unique dead-end street, right, in an overall much larger area that we find this anomaly, and I believe that they're well within the character and there will be no substantial detriment to the public good or the intent of the zone plan by this one waiver for this specific piece of property.
Okay, thank you for that. I just had a couple other comments and / questions. So I was just looking at the neighboring properties across the street. It seems like the minimum driveway width for all of them is 18 feet, which helps with the parking. The concern I have here is you have 2 parking spaces in the back. There's going to be 2 families, so right now it's all one cohesive family, but if ever this is sold off, how does that get managed now? You only have 2 spots. How do you keep the driveway from being blocked in the future?
Right, so the requirement is 4 parking spaces for the units. We've conceded to the 2 parking spaces, and the testimony is such that there is significant on-the-street parking, specifically in that site. If I may approach the plan once again. When you're looking, and we're looking at the tax map again, if you look on the north of the map from the corner spot, this is all park. It's the entire, well, it's more like center, left center, all the way back, down. There's no properties there. It's just, and it's not the main entrance. I'd have a different conversation if this would have been on the other side where the parking for the park is. But that has its own separate parking, its own separate entrance, more closer to first base and home plate. You can tell I like baseball. So. And they have, so there'll be more than 2 parking spaces available along that side of the street that are not being used for residential purposes, right? It's if somebody wants to go through that section.
Correct. I guess the question where I was getting at is access to that driveway needs to stay clear in order to reach the tandem spots. How are you going to prevent somebody from parking directly in the driveway? Say there's a new owner, there's 4 cars now, and the 2 spaces are taken. What's going to prevent somebody from parking 2 cars in that driveway?
It's the same thing that would prevent anyone from doing it right now in any other of the driveways, right? So.
Well, I disagree. Those are 18 feet wide.
Say that again?
Those are 18 feet wide, so you can fit 2 cars in, and 9 feet. That's
right,
why.
but but if you look at a lot of them, they don't have the K-turn we have. So a lot of them have to back out into the roadway.
Oh, no, I understand that. I guess what I'm getting at is what's going to prevent somebody from parking the driveway? Would you do
So
that?
that's self-regulated, because I know if you block my spot, we're going to have some words, right? Because I want to get out, I got to go to work, I want to try to get there, so I want to try to.
Yeah, I just don't want to leave borough officials trying to police a tenant matter. That's where I'm trying to go with that. So would there be any kind of, restriction on parking within that 10-foot, 12-foot lot?
So I think what we could do if the board wanted a condition that the leases, right, would be for a specific unit, right? So let's say for whatever reason, the children move out, right? They're gonna lease the space to someone else. Normally, under normal circumstances, if it's a 2-family house and there's not enough parking, the leaseholder, right, the owner or one that's leasing, will kind of make those spaces available or not available depending on their needs. So that could, understanding what you're saying now, but again, I want to reiterate, even though you got two cars next to each other, they back out into the road, we won't have that need.
Oh, it's a safer movement, I agree. I'm not disagreeing with that.
Right, so, right, we're looking at the positive and negative, right? And the board specifically says you wanted cars to come out head first, and that's what we're able to do here. And understanding the engineer's point, usually there's some self-regulation because if I'm the property owner, you know, in my lease it'll have some sort of language in it.
And if there are any conditions, of course, the applicant is willing to comply
Of course.
and take any suggestions that the board wishes to impose as a condition for approval.
And if you go to the next plan sheet, I believe it is, I was waiting for your testimony too, because there was questions about buffering, and I don't know if this would be more planning or architect, that you're going to comply with the ordinance.
So that SO1, is that the one we're looking at?
Let me just double check. Yes, it is. So with this layout here, there's 5.8 feet in green space to the west, and then the AC units are almost right on the parking spaces. Now, the testimony before was that they're going to comply with the ordinance. I'm just concerned that there's a 3-foot buffer that's going to take up one of those spots, and a 10-foot buffer is going to come in the other direction. So if you guys can maybe clarify your testimony on that a little bit?
Yeah, so I can tell you that meeting the 3-foot buffer towards the rear of the property is not something we're gonna be able to do, right? Now, that being said, you don't wanna lose a parking spot, right, for the buffer. And secondly, what you have here is a wall. There's a solid concrete wall of a commercial property that faces the other block. So you're really not buffering it from any, you know, neighbor, you know, or any of that type of scenario that you would require a buffer from the residential side of it. We can very easily comply on either side of the unit, so complying for the left or the right, where if we're looking at the left side, the neighbor would see it, that won't be a problem to do that buffer. And then on the other side is the ball field, and I can tell you with all the fencing and the grass that's on the other side of the ball field, we'll still comply, but it's even harder to see it, and it's not, you know, right? The whole point of the buffer is from a residential area to not negatively impact your neighbor. In this case, we could definitely not impact our neighbor. We're definitely not impacting the rear neighbor. That's a solid brick wall, which is on the property line, by the way, that there's no setback. It's on their property line, and then you have the ball field on the other side, so we will be able to comply with either side of that buffer.
Thank you.
Mika, you have anything?
No, Mr. Hernandez, just so I understand, so you won't be able to provide the 3-foot around the HVAC, so we're gonna seek that as a variance.
As a design waiver
Yeah.
for only, we'll do 2 out of the 3 sides, because one side's against the building. So we're requesting for 2 out of the 3 sides so that the rear portion.
Doesn't take away from the
Right, so
parking.
1, we don't want to lose a parking space.
Yeah.
Or we'd have to push the parking space back. And 2, there's really no residential impact to that rear because it's a solid brick wall. So you are.
So that 10-foot also, you won't be able to, because right now what's shown is 5-foot, you'll stick to that, right? In the rear wall, on your plan?
Well, we meet the lot coverage.
Yeah,
Oh. So
when
there's
you're
no
looking at
setback.
it, forget the HVAC, the second requirement is the buffer from the commercial property, which is the rear property
Oh,
you're
okay.
talking about. That's the 10-foot. Right now, the plan shows it's only 5-foot there. So I want to make
yes,
sure
so-
that that will also not
Yeah,
be
that's
met.
this. Yeah, the same exact thing I said for the HVAC,
Yeah.
for that back wall, because what are we buffering from? A brick wall, right? So it's like opening a beautiful window and you see a brick wall. That's kind of what you have.
So they'll need a variance from that.
Yeah,
But
design
the
waiver.
testimony is that because the adjacent commercial property has already a brick wall there, they would provide another 5 feet, put some kind of plantings there, and still have the 2 parking spaces.
It essentially
The intent of
self-buffers.
the ordinance.
It essentially self-buffers itself.
There's
To a certain extent.
there's no windows.
To a certain
It's going to
extent.
the intent of
No, no,
the-
yeah, there's no windows. There's also, just for the board's application, that's a solid wall. There's no windows there. It's not like they're, in fact, it's on the property line. You can't really have windows there under the code because it's closer to 3 feet to the property line. So that, the question is, if ever, I mean, that doesn't change. That can't have a window anyway.
That's it.
Can I ask-
Anyone from the board? Frank?
Yeah.
Mr. Mazzio?
So, the testimony, the main reason for doing this, we're saying, is basically to allow for multi-generational living, letting family combine. Why don't we just do our bulk ordinances are pretty liberal as far as what we can do on a 50 by 100 lot. Why isn't it just a one-family house? Why do we go for a variance that's looking for a 50% deviation from what the current ordinance is? Is there a reason for that?
Because it still adds to greater privacy for the family that's going to be above. I mean, it is a, for all intents and purposes, a mother-daughter type of situation currently, but, you still want to have separate entrances. You want to have that sense of separate homes sometimes, as opposed to it being, a single-family residence.
There is a move, and there is in the state for multi-generational living where you can architecturally design a house that allows for separation, and you do have room to do it. I built them, so it's a big ask as far as the bulk, the C variance. And I'm just curious as to if that's been considered. Did you look down on a piece of paper and say, hey, these are our options, and lay it out? And
So they're adult children.
Yep.
They're going to have their own families. You heard the number of grandchildren that are there, having a specific unit for them. Typically,
Are the children going to live on their own?
I don't know how you design them. And usually, when you're looking at these mother-daughter type of situations, they're usually limited number of bedrooms just for the elderly that are living in the house. It's not really a unit for younger children. They can pass this on when the parents pass on to their other children that are there with their own families. So there's more than just, that type of situation, right? You want to be able to do that, as well as there's also equity and value in that where they can use to invest in the future. So understanding what you said, and understanding the big ask, it's very, very similar to everybody around them. So it's not, I'd understand if this was an anomaly. This is very consistent with the other units in the neighborhood.
Anyone else? With us? York Street. So, let me ask this question. With the separation with 2 apartments, you would need 4 parking spaces. So, off-street, we need 2. Why 2? If you have a separate apartment upstairs.
So there's 2 per unit that's required under the code. So because we can't fit them on site and tandem isn't permitted, right, we're requesting a 2-spot parking variance to accommodate the board's requirement of 4 parking spaces. So basically the way it breaks down based on the number of bedrooms that we're proposing, it would require 2 per unit, and we're providing 2 very clearly, very easily meeting your backing up, because it was 24 feet. We're giving you more than 24 feet on the back up to do the K-turn, which then leaves, because, like you guys said clearly, what stops them from blocking the driveway, right? We're asking for that to then be accommodated on site. And my testimony, based on the location, based on what's neighboring that property, that that roadway can accommodate 2 parking spaces that we're short on site.
Right, you mentioned in the future that one of those apartments could be leased outside of the family. And in that situation, you cannot rely on off-street parking. You have to provide on-site parking for that apartment. How would that be done?
So basically what we're saying is that there'll be 1 unit that'll have the 2 parking spaces, or another option is that each unit, like let's say these are scenarios that I don't know will ever happen. I'm just running because I understand this goes with the land, and you got to look at any scenario, right? So let's take another scenario. Let's say both of them are rented out, right? They're both non-family. The leases can say that each one of those units get one of the spots in the back, and then the other 2 spots have to go on the street. So there's multiple ways to do that through a leasing arrangement. That is very common in 2-family houses, especially owner-occupied 2-family houses, where you put in the lease, you get this spot, or you don't get any spot, you have to go on the street. So that's how kind of it would work out.
Yes, Mr. Scudery.
So you said there's gonna be 6 adults in the house?
No, right now, there is gonna be 4.
2 parents, I know you said there was 2 kids and 2 other kids.
No, so right now, the other 2 children with all the grandchildren live in a,
Separate house.
and they're not coming. The two other children are coming to be caretakers to the parents. So, right, there's gonna be I guess, brother and sister in one unit, and then the parents in the other unit.
Because I had 13 also. I had 6 adults and 7 grandchildren.
Yeah, that's what I had. So if that changes.
Yeah, no, so no, I'm sorry, if I made that confused. What I'm saying is, the grandchildren are coming over, not to stay, but to like enjoy time with their grandparents and their aunts and uncles, and they wanted the space. So I meant that to clarify the reasons why there's finished spaces, why they finished certain spaces that maybe they didn't want to.
That just changes the parking
Yeah.
when you're already having 6 people driving.
Yeah, no.
That was my next question.
Now I understand why you're asking the question. No, that's not what we're saying.
Well, the question also goes to that what's happening right now, we understand why this needs to be done. But the moment that changes and you lease out the first and or the second floor of both, then the ordinance now gets a little bit shaky because we're supposed to have 2 per unit. We're supposed to have 4 off-street parking spaces. And you're saying we can't get that. We need 2, you're saying you can only have 2, but 2 off-street. That makes it a bit difficult for the board.
So we're trying to balance the request that you have of no tandem spaces, of K-turning and coming out straight forward with the 4 spots, right? So,
K-turn.
go ahead.
The K-turn to me is not an issue on North 15th Street. It may be in the ordinance, but
So so it requires it in the driveway itself. that you
in the
do.
driveway.
Yeah, that's what your ordinance says. So then we were balancing, weighing that, okay, we're gonna comply, make sure that they can cater in our lot to come out versus the tandem, right? Which makes that catering very difficult and would almost require the backing out. So, I mean, it's really up to the board if you want the K-turn or you want the back out into the street, right? So that,
So the vice chair was just saying to me, where is that say that you could K-turn inside your driveway? Everybody backs out of the driveway.
it literally says, in fact, it came from your planner's report.
So that comes from the engineering report. So for a 2-family use, it does talk for a turnaround area.
Right.
It doesn't specify specifically K-turn, but that's how he's referring to it as. The one caveat is this is also a pretty low volume street.
Right.
So the need for the K-turn might not be as practical as on a busier street.
Not as low volume. When, that Little League field, having 3 kids that play at that Little League field every night, it's, it gets crazy there. And there's a couple spots at the end that are double gates that you're not supposed to block. So you kind of lose that. Yeah, it gets crazy and there's kids running all over the place. It's just that back section.
I have a question too.
So it is crazy with the,
Sorry, I have a question.
Mr. Pantini?
Yes. Working on Mr. Mazzio's comment about, what did you say, multi-generation? Okay. Another scenario. Obviously, you know, what you're providing and what you're suggesting is good for now. But we know how things work. Now is good. Future, sale, tenants, lease, whatever. We sell the building, we got a 2-family house, we're short of parking, you can't use the tandem parking, use the street where it's a problem. So, I'm not telling you what to do, just throwing out another option. So, RSIS says requires the parking standard, right? So it's what, 2.3 for 2-bedroom, 2.4 for 3-bedroom. Anything over 4 bedrooms is still 2.4. So you'd only need 3. And if it's only a 1-family with 2 stories or 3 stories or however many, I'm not an architect, but you could have, no, I'm not going to say you could have as many bedrooms as you want, but you could work it out where you probably only need 3 spaces, and 3 spaces controlled by 1 family is easier than trying to coordinate 2 families with, I'm in the driveway, I'm not moving, I'm in the back, I gotta get out, what are you gonna do? So, I'm just saying, that's another scenario whereas if it doesn't work.
Excuse me, Nick, Mr. Fernandez is correct. Can I get, who's in the back? Can you help us out with asking the people in the hallway to lower their voices because we can't hear up here and it's being recorded? Thank you very much.
So
I'm sorry, Mr. Fernandez and Mr. Fernandez.
So what I was trying to say, I don't know what you heard, what you didn't hear, but if you have, right now, if you have a 2-family house, you're required for 4 spots. And right now, with the 1 family, it works, but with the scenario of 2 families where the owner leases out both apartments, it could be kind of sketchy, like the chairman said. Like, you know, I'm in the back, I gotta get out the front, I don't wanna move, it's 3 o'clock in the morning, I gotta go to work, whatever. If it's 1 family with multiple bedrooms on multiple floors, within the ordinances, the 30 feet, I'm just saying, anything over 4 bedrooms is the same on RSIS. It can only be like 3, it'd probably be 3 spaces. In which case, the one in the driveway, I know you're smiling because it works, but the one in the driveway can work because now it's only 1 family, move, and I'm getting out.
I'm
just
smiling
saying.
because it depends on the family member, right? Because
No, it does.
they may throw something at my head if I'm blocking them in the morning to go to work. I'd be more likely to do it because it's my brother than if it's a neighbor.
Well,
right? I may be a little bit more cordial
I
than if it's like
understand
my
that.
own family member.
But you get it, like right now it works. Right now it's, and I'm not saying it's a hardship, but right now it works for the family setting. But once it doesn't work, or once that family setting moves, then we got two
But what we're
apartment
really
blocks.
talking about is, under your scenario, what we're really talking about the difference between one and the other is 1 parking space at that point.
But no, what we're talking about is coordination of the parking spots on site. That's what we're talking about.
And what we're trying to say is that there's ways to do that through legal documents that give it more weight than a verbal agreement, right? So that's kind of where we're at, and you're getting a much better product, and you're raising the housing stock in the area, and it's, in my professional opinion, it's consistent with what's there. You know what I mean? And we'll be, just like the engineer's discussion with me is, we're gonna be one of the very few that can actually come out head first on that block, which I think is a benefit, especially what you just said, Commissioner, with the kids playing back and forth. Nobody's backing out if there's a kid running after a game to get to their parents' car, because we're coming out face forward. But I understand exactly what you're saying, Commissioner. I was just thinking of my own brother, and I'm like, oh wait, if that was me, he may hit me with something.
Any other questions from the board? No? Are you completed with your testimony, sir?
I have completed my testimony.
And no further questions from the applicant, no further witnesses. Ms. Ayaghazi is here if the board has any questions, but she's not really here to testify specifically. We didn't intend to have her testify, I should say. But if there are specific questions, we will.
Well, what we're going to do now is someone's going to make a motion to open it to the public to discuss about this application and this application only. So let's see what happens.
I make a motion to open the hearing to the public.
Motion made by Mr. David, seconded by Mr. Clemente. Is anyone in the audience wishing to comment on what the testimony you just heard? Okay, looks like none.
Make a motion to close the public portion of the hearing.
Okay, motion again made by Mr. David, seconded by Mr. Scuderi. All in favor?
Aye.
Okay. I guess we heard the testimony, and we have to make any last comments from the engineer and the planner on any which way that you could advise the board so we can have a clear picture, and then we could talk again amongst ourselves and make a determination of what we need to do.
Thank you, Mr. Chairman. So the applicant before you is seeking is converting a single-family use into two-family. They require variances for the lot area. The required is 7,500. What the site is 5,000 square feet. They also need variances for the off-street number of parking spaces. They can provide 2 on the property. They require 4. The driveway width, which is, it's required to be 12 feet in width. This proposal does have a non-conforming driveway width at one area. It's almost to 10.8 feet, and it's not being changed, so that variance is going to remain. Lastly, the applicant, through testimony, did confirm that they would need waivers for the HVAC buffering of the 3 feet. They will be able to meet it on 2 sides, but not along the proposed parking area that they have on the site, as well as the variance for the buffer width from when they're adjacent to a non-residential property. So those are the requirements that are before you. Typically in this zone that they are in, which is the
R5A.
R5A zone, thank you. The requirement is for a 2-family, you need a 7,500 square foot lot. For a 1-family, you need 5,000 square foot lot. The applicant, through their experts, the architect as well as planner, provided you the positive and the negative criteria as to why they think the board should look at this application favorably. And they've made some arguments as to how the impact would not be substantial on the adjacent areas.
Thank you. Mr. Massey?
Sure. So we've gone over Mika has gone over the parking requirement. This one thing, as I look at this more, we should consider is that, as the planner said, there's only 24 feet needed for a back out. Right now, that front tandem spot being going away, the paved area is almost 30 feet. I recommend a reduction in that area to what's necessary for a proper K-turn. And since you're gonna have headlights pointing at the neighboring property, if the board would consider this, I'd recommend some buffering or planting to block headlights in the future. And then the other comment that I had still holds from before with access to the basement. So there's 3 access points to this unit. The front, which is for the bottom unit, and then the side, which goes to the top unit. Then there's still that basement access, which gets me concerned, because there's the possibility of different tenant over time to take that basement. I know it's not zoned for it, there's no kitchen there, but there's a full bathroom in that basement, and they have a completely separate access. So it's something the board should weigh upon.
Okay. I thought you were raising your hand.
Yeah.
Okay, so we just heard from our planner and our engineer, and I have a couple of concerns. Parking is one of them, it's in a major one. But I am looking at your plan, and I noticed that you do not have any bedrooms in the attic space, nor in the basement. As part, if this application was to go forward and you were approved, part of that application would be that there would never be bedrooms up on the attic space nor in the basement area, if this was to move forward. And we would want that as part of a condition, that you cannot have bedrooms there, specifically for safety, egress, and things like that. Now, I did notice in the front of the plan that those 2 windows in the front of the house look like egress windows. And they look like egress windows maybe for future plans of making that a bedroom. I'm going to really stress, if this is approved, that you do not make this bedrooms, that you would come back before the board, you would do something appropriate for the safety of the people that are living in the house. I'm not saying that it's going to be approved, I'm just saying that that would be some of my additional requirements. It also looks like you have a separate entrance, not just a way to get into the backyard, but that downstairs dwelling, to me, it's clear, it looks like an entrance. You could call it a way to get to the backyard and have the children run up to the second floor, but also part of that condition, that would never, ever be a three-family third apartment, whether legal or illegal, well, illegal apartment, let's put it that way. It cannot be. It needs to have all the requirements set forth by the board, should it be approved. Those are my statements, combined with the planner and the engineer. Anyone else need to add to that? Okay. I'm sorry, Mr. Clementi.
So we have some concern about the basement access from the rear, we could eliminate the door.
Well, I am a little apprehensive with eliminating the door for a second means of egress. There is some safety issues that I would, I'd like to see, but, that's a consideration from the planner and the engineer side that, Mike, can you weigh in on that, taking that door out of there?
I mean, there's lots of houses that don't have doors there, but, the more entrances,
The better off.
The better off.
Yeah.
Especially if there's gonna be a lot of children playing in there.
I'm sorry, Mr. Clementi. If you don't leave the door, take away the bathroom?
Make it half bath.
Make it a half bath. Interesting. Interesting.
Mr. Chairman, if I could
You already
propose a
have four
suggestion.
I'm sorry?
If I could propose a suggestion, if you like.
Sure.
We'd be totally amenable to a deed restriction, specifically outlining what restrictions you'd like to impose. But I also believe the applicant was also considering if you'd like to reduce it to a half bathroom. That's also agreeable.
Okay, I have to go back to the planner and the engineer to that request, because a half bath is a lot different than a full bathroom, which could later on throw in that little kitchenette and have that. First of all, let me be perfectly clear. I don't think anybody is going to do that in the way that you presented your case, and I know that these are very honorable people, and they probably would not do that. But in the future, if somebody decided to move out and do whatever they have to do, a deed restriction would be very, very, very amicable for this application. Mika?
I agree with you, Mr. Chairman. I mean, as a condition, if the board were to look at this favorably, putting it on a deed is much easier to find rather than it remaining as a condition of approval in some resolution. The second part of it is asking the applicant to make it into a half bath. How do I put it? Like at least it deters somebody from making a full bathroom, adding a kitchen for what it made. It delays the process a bit further if somebody has to convert the third illegal unit. But that would again add a little more of another restriction on the property, keeping it as half bath, keeping it as half bath in the attic, so that it's not an easier conversion without going for permits.
Thank you. So these are just my suggestions and recommendations as far as the conditions are concerned, but now we have to put it before the board.
Well,
Did you have
I just
some-
have the same questions that you did or concerns. The attic.
Sorry for that. We have about 70 people here who've been waiting over 2.5 hours. Could you
wait.
let us know if we're going to be able to speak or not,
When
just
you
for the
hear-
convenience of everyone here?
When you're here at the beginning,
Yeah.
okay. There's people that have an application, you have now slowed the process up that you wanted to go.
Oh, absolutely. I apologize.
Have a good one.
When are you prepared to let people speak or tonight? They want to know so they can go, and then they can get back to
If
it.
you continue to talk, we're going to take a recess.
I just want to answer the question out of respect to the people that are here. Respect the audience that is here.
The application's on
Show
front.
respect. It's disrespectful to take 2.5 hours for 2 cases. You can't get a canopy over a deck here. You're going to waste all everyone's time. Let us know when we can speak.
Adjourn the meeting for 5 minutes.
With all due respect, we are close to the end.
motion on the table to adjourn for 5 minutes? Okay. Motion made, okay. We're going to adjourn for 5 minutes so everybody can control themselves. Motion is made to open it again by Mr. Scuderi, second by Mr. Pantina. All in favor?
Aye.
Okay, we were at the point where we were talking about some conditions, and the conditions, I don't know if our planner engineer or the attorney wrote them down before we had to wait 5 minutes. However, I think we were talking about a smaller bathroom in the basement.
Correct.
We were talking about deed restriction for the property. And we had, what else? Was there another item?
Deed restriction about the tandem parking.
And deed restriction about the tandem parking, you said, Mr. Mantina?
No bedrooms said that, right.
Is that right?
In the basement.
I'm sorry?
No bedrooms in the
No
basement.
bedrooms in the basement and the attic, okay? Those were some of the conditions combined with what the planner and the engineer had to offer. And to the attorney, are those things amicable to your clients?
Yes, they are, Chairman.
Okay, that doesn't mean you have been approved here or denied. It's going before the board.
Just one question, I think our planner mentioned that we're going to be more restrictive on the attic apartment and basement apartment. Was that the deed restriction you're talking about?
Yes.
Okay.
So if the condition is that the board is looking at this favorably, they can say that as a condition, we ask the applicant to have a deed restriction on the property so that the basement cannot be converted into an apartment and the attic cannot be used as a bedroom.
Or apartment either, right? No?
Or you can have the basement
Yeah.
also not to be used as a apartment.
Well,
The
that's-
attic
that-
becomes a little difficult because it doesn't have a separate
Okay.
entrance.
Okay, I
but the
understand that.
basement
Okay,
does.
okay.
But that's got to be monitored, after it's out of here, that monitored,
Yeah.
is
Well, I'm
monitored
saying
by the building
deed-
department.
The deed restriction is more restrictive than us just saying this.
Oh, yeah, oh, yeah, we can say anything we want.
Okay. Thank you.
Yes. Okay. Well, now it's up to the board to make a motion how you want to look at this. The board members have to make a motion.
I'll make a motion with the deed, with all the restrictions we just put on
Okay.
To approve?
to approve.
Motion made by Mr. Ladati to approve. Is there a second?
I make the second, Pantina.
Second by Mr. Pantina. Roll call.
Mr. Paterno?
Yes.
Mr. David?
Yes.
Mr. Clementi?
Yes.
Mr. Cantina?
Yes.
Mr. Mazzio?
No.
Mr. Ladati?
Yes.
And Mr. Scuderi?
Yes.
Okay. Congratulations, you got this. Thank you very much. Yeah. Also, I would like the attorney I would like the attorney, the planner, and the engineer get together to combine those conditions and everything, get it off to the attorney and the applicants. And congratulations, welcome.
Thank you
Just for the
very much.
record,
Thank you.
Council, just if you could
Okay.
also draft what the deed restriction would be,
Absolutely.
so that we can see that in the interim, that would be very helpful.
Absolutely.
All right?
Happy to.
Then when you and I can go back and forth on that.
Sounds good.
All right?
Thank you very much,
Thing
Board.
here.
No problem.
Next one is here we go. Okay, the three. Did you give Joe DeMarco the book of time? He has to get it by law. Ten. He made the announcement when he came in. Yeah. What's that? He said he's going to use it.
He's got his fill.
Okay. Okay. We ready? Everybody ready? Okay, here we go. We need a motion to open the meeting to the public.
So moved.
Moved by Mr. David, second by Mr. Scuderi. All in favor?
Aye.
Anyone from the public wishing to come up and speak?
Just a reminder, it's a 3-minute limit, so we can accommodate as many people as we can.
To confirm, did you pass a CoreWeave agreement on May 15th of 2025?
Are you asking us a
Yes,
question?
I was asking for confirmation. Was it, to know I had the date, was it May 15th, 2025 that planning was passed here?
This is public comment.
I'm asking you a
No,
question.
I understand what you asked. It's public comment.
Could you answer it?
We're not sure. Very confused.
So there was a resolution previously passed for CoreWeave in last year, 2025, yes.
Okay. I live on the border of Kenilworth and Cranford. I want to know, at that time, as I understand it, you then informed Cranford. Is this correct or not?
Well, I'm not going to answer all these questions. So take your time. Because it's public comment, not public question.
So we don't have a right to know.
There's no difference.
There's a big difference, so continue on,
That's
sir.
great.
I need to know for the record if Cranford was informed at that time or not.
Obviously, your answer is.
Do you have is there a reason, what's your problem? Why are you not answering?
Why don't we have a
Do you
right to
are
know
you-
this?
well, what's going on? I just need to know if you informed Cranford.
My freaking tax money's paying this guy. Can't answer the question?
Did you inform Cranford or not? Yes or no?
Sir, do you have any other comments?
Yeah, I do.
Okay.
I'm here with an attorney in the Kenilworth Planning Board that refuses to tell us, and all 100 people waiting here tonight for 2.5 hours, if he informed Cranford, the town next door, about the CoreWeave project that was passed here May 25th of 2025. He's refusing to answer. I'll give you another chance so everyone can see you. What is it? Did you pass it on? Did you inform
Again, this
Cranford
is
of
the
it?
public comment section. So,
Actually, it says open
to the public.
discussion, open meeting to the public.
Correct.
No comment.
Sir, you got 40 seconds left.
Hey, kiss my ass. Can you use my 40 seconds? How about showing respect for the people here that come out here for 2.5 hours? Answer the questions.
You now have 30 seconds.
Oh, really?
They can't answer yes or no. Wow.
So 2.5 hours, you won't answer our questions that we're waiting here to
We
ask.
can talk about that. Answer must be no.
So you hid this from Cranford? You hid this? Did you hide it from the neighboring towns, yes or no?
Yes.
The agreement with CoreWeave?
Sir,
Yes or no? Answer the question.
So that's your time.
Don't talk to me.
Yes.
That was your time, sir.
No, screw you.
Next person, please.
Thanks for nothing.
Next person, please. Is there no one else who wants to speak?
Everybody wants to speak. We will be here till
We'll get
7
up.
o'clock.
I'm just curious
Could
if,
you just please state your name for the record, please?
I don't have to.
Not a problem.
Absolutely not. I would like to know if you have errors of omission insurance, because I have a feeling every single person sitting up here is gonna need it.
And you know insurance, for that matter.
I guess we don't answer
Yeah,
that.
so this
But I
one-
guess when we get an attorney, you'll have to answer it when you all get sued.
Yeah. You ready?
There is errors of omission insurance, and you are omitting. Can't even answer a question.
Hey, this is unacceptable.
I'm asking you, I'm
Don't
asking the board up here if they have that insurance, because they're gonna need it.
This is the planning board, ma'am. The
Okay,
Insurance is procured by the township. I do not know what policies
They could answer, or they would know if they had it, because they
they
paid for
might
it.
not know.
Errors of omission insurance.
Can we request certificates of insurance?
You can make an open request to the clerk for all insurances
I will be here
available to
tomorrow
the town.
That's if they omit to the public.
Hello, I don't have any questions. I'm putting something on the record. So I have brought this to the attention of the Borough Council, and tonight I wanted to bring it to your attention for the record. This is in relation to application 26-002. The current applicant is CoreWeave. They are not currently the designated redeveloper for lot 1.0102. Designation lapsed for C.W. Grosbeek's Nest Urban Renewal LLC, April 13th, 2026. This application was voted on April 28th, 2026. There are no minutes available for the April 28th Planning Board where the vote was taken, so there's no presentation for the constituents to review. The application was not submitted under the proper named designated redeveloper, and regardless of that, designation lapsed 2 weeks prior to voting. Currently, there is no executed redevelopment agreement, and with the lapse of designation, they are barred from construction without an executed agreement. This is not the first time that this has happened. The redevelopment agreement deadline lapsed in September of 2025, and again after the single permitted extension on April 13th, 2026. No agreement has been executed, and yet construction continues and approvals are made. I request that the board defer action until the designation and agreement issues are resolved, and that any approval be conditioned on a community benefits agreement. Any show of good faith has certainly expired. I will also request that the resolution today and the full application packet be provided in the minutes for this to review, for the public to review. All plans and application materials must be on file for the public to review. That's law. I also would like to request Robert's rule be suspended today by a 2/3 vote, as everybody was waiting. So I would like to pose that to you, a 2/3 vote to suspend Robert's rule tonight, or at least push it out another hour. Anybody want to pick that up?
Just in terms of the time of the meeting,
The ending time.
well, we might get to that at the time, depending on.
That is 10 p.m. You can suspend that,
No, I
the
understand,
lift of
but
10 p.m.
We're not there yet, and I don't know where we'll be in the next 20 minutes.
You could choose to do that now. No? Any concerns about the fact that you approved an application for a non-designated redeveloper? They're not the redeveloper for that plot.
So you're at your 3-minute, 10-second mark.
I use my time.
Great.
I yield my time for
There's no yielding of time.
They're not going to answer any questions, but I wanted that on the record for the Superior Court of New Jersey.
Thank you.
Good evening. My name is Annette. I'm from Cranford. I understand that tonight concerns the memorialization of the subdivision approval for CoreWeave, and that the board is not being asked to decide what may ultimately be built on these newly created lots. However, I respectfully ask the board to consider what this subdivision represents in the broader context of the project. On April 28th of this year, I asked the board attorney here to explain the applicant's options. The word being options here, there were choices afforded to CoreWeave. There were no choices afforded to the community. He explained that CoreWeave could have come before the board with a complete package, a subdivision together with a site plan showing what it intended to build, allowing the board and the public to evaluate traffic, noise, operations, water demand, electrical infrastructure, and other impacts together. Instead, the applicant chose to bifurcate the process and seek subdivision approval separately. That raises a simple question. I've raised it before and I'm raising it again. Why? The subdivision itself may appear routine, but there is nothing routine about the consequences of expanding a 40-megawatt data center fivefold. There is nothing routine about a project reportedly approaching 250 megawatts of power demand. And there is nothing routine about dividing a project of that potential scale into separate approvals that prevent the public from seeing the full picture at once, from understanding how these pieces will affect their lives wholly, not in parts. Each piece of this project has come before the board on its own. A substation, then a building conversion, and now a subdivision. Viewed separately, each application appears modest. Viewed together, they suggest a project substantially larger than the single facility that has been discussed publicly. We know this because CoreWeave has spoken about, quote, first 40 megawatts, unquote, about, quote, landing and expanding, unquote, and about bringing the project, quote, to scale, unquote. The company later accepted a state incentive requiring 143 jobs, and borough resolutions describe approximately 550,000 square feet of data centers, even though the current building is approximately 247 square feet. I'm not asking the board to speculate about future applications. I'm asking the board to acknowledge that the public record already points to a project that may be significantly larger than what has been presented, one application at a time, and this is the reason that the other communities were not notified. I'm asking whether or not this is occurring, whether or not this is occurring here, the concern is legitimate. When projects are reviewed in pieces, it becomes difficult to evaluate the cumulative effects, the impacts, including infrastructure demands, environmental consequences, and long-term quality of life impacts.
Can you just wrap it up? Sorry.
One example is noise, not simply whether a single building complies with today's ordinances, but whether the community is prepared for the cumulative effects of a large-scale AI data center campus operating around the clock. These are the questions that deserve consideration before the full build-out is realized, not afterwards. Because I have to say, and I'm finishing now, there is no fire truck, baseball field, or short-term financial benefit that can adequately compensate for the long-term impacts if the ultimate project changes the character of this community or places burdens on residents that were never fully evaluated. I ask to be put in this record as this resolution is memorialized tonight. This is my last sentence, I promise. I respectfully ask that the record reflect the continuing concern of residents that the ultimate scope and cumulative impacts of this project have not yet been presented in a single comprehensive manner. Thank you.
This is very important. Okay. This is for the record. On June 17th, I was at the council meeting and I asked Ms. Paserno, the councilwoman, about a bid put in for around $46,000 from the company Paserno Giordano Construction. The project that they bid on and were awarded was the Orchard Brook Water Restoration Project. Orchard Brook Stream Capacity Restoration Project. So, when I asked this question on June 17th, I was told, no, why are you asking me that? What do you do for work? What do you do for work? Is it anybody's business up here what I do for work? No, thank you. So I will read for the record from the City of Rahway, the public notice. The Municipal Council of the City of Rahway has awarded a contract through the fair and open process pursuant to NJSA 19:44A-20.4. This contract and resolution, AR-128-26, authorizing it, are available for public inspection in the office of the municipal clerk. The contract has been awarded to Paserno Giordano Construction, LLC, for a fee not to exceed $46,500 for the Orchard Brook Stream Capacity Restoration Project. This company complies with the requirements of PL.2004 C19. That's Heather Capone's the city clerk of Rahway. So is the city clerk of Rahway lying about a bid? Anybody? Did you win that bid, Mr. Paserno?
So you're asking me if I win a bid?
Public, yeah.
You're asking me about my personal life?
You're a planning board member. This is on the public website for Rawway. So can you answer to me how that is your personal life?
Because this is not Rawway, this is Kenilworth.
So he's right in front of me.
I-
So what I'm asking, because he is for Kenilworth's Planning Board, correct? The Orchard Brook Restoration Project was one. That wasn't Rawway, right? That's technically what, Cranford?
The contract that you just read was from the town of Rawway.
So why did Ms. Paserno tell me no? What do you do for work? Mr. Paserno, did you win the project? Yes or no? It's a very simple question. It's public. I'm going to post it anyway. You know I'm going to put it up there. So just answer the question. Did you win the project?
Mrs. Paserno answered the question.
She said no. What do you do for work?
She answered the question.
And you guys all think.
Yes or no? Did you win?
So the councilwoman
Taking that money?
answered your question.
You all think that?
Did you win the project? Did you win the bid? $46,500. Did you win the project? Orchard Brook Restoration Project.
For a contract in Rawway.
I'm asking the man sitting in front of me in... Are we in Kenilworth?
Yes.
Yeah, okay, so I'm asking for the person in front of me in Kenilworth.
Nope, that's fine, your time is up.
Yes or no?
Your time is up.
Did you win the bid for the Orchard Brook Restoration Project?
Your time is up.
It would be way better for you if you said yes, honestly. Because if she told me yes the other day, I would have left her alone. But when she said no and asked me what I do for work, so here's my question.
Other people that would like to.
I understand. It's 9:50, right? Yes or no? Did you win, Mr. Paserno? The chairman of planning board, did you win? Cricket, cricket. Is your wife a liar? Did your wife lie? Did your wife lie? Did you win?
Now, there is, just so we're.
I should deserve an answer to that. If I'm told no, and the answer is clearly on yes, there should be an explanation as to why an elected official is lying to people asking questions that are public record. You all swore to some form of oath, correct? To serve and do your job justly and fairly, correct? And all the council served an oath, right? There's an oath there? I'm sure honesty is in that oath somewhere.
And you don't like it.
So yes or no?
Your time is up.
Okay, I don't care. What I'm asking you is yes or no.
What will happen is no one else will be able to speak.
Oh, okay. So for the record, it is very, very public that Miss and Mrs. Paserno, Mr. and Miss Paserno, won the bid. Miss Paserno, an elected official, blatantly lied on record and then had the audacity to ask me what I do for work. I think that should be clear. Thank you.
Good evening. The anonymous planning board attorney made it very clear that we only have 3 minutes, but you guys did a masterful job of wasting 2.5 hours on a 10 by 10 gazebo and someone converting a family into a 2-family home. So kudos to all of you. Masterfully played. Almost 2 months ago, I stood up here and very respectfully expressed my concerns with CoreWeave requesting that a subdivision of the lot into 4, and expressing that it gave the appearance of potential, well, let's say skirting around some things, hiding some things, because it's kind of unusual to subdivide a land into 4 and simply say, we don't really know what we're going to do with it. We don't have any plans, even though here's the specific borders we wish to have. Here's the specific lots we wish to have. But lucky for me, it turns out public records answered the question for me because you people did not. You refused to answer the questions at that time. You refused to tell the public what CoreWeave intended to do with the lots. So you made it clear that you're not answering any questions tonight. So I'll use this time to make sure that the public is properly educated. We have public records that CoreWeave plainly and clearly informed officials of the borough that they intended to build a total of 3 data centers on the 4 subdivided lots, plus a mega-sized substation, with the one single data center being converted now, sitting on one of those 4 subdivisions. Interesting, isn't it? And yet this board has repeatedly, this board and the council has repeatedly refused to answer the public's questions, many of them very specific to this. Are there additional plans? Are there additional data centers coming? What's more interesting, CoreWeave's application to this board states within the application their intention to build additional data centers on the lots. It's said in the application itself in handwriting, it's said in the attached letter specifically, it is mentioned in emails as far back as July of 2025 in which Michael Ash, a borough attorney, emailed the mayor of this town and told her they just bought the whole lot and they plan to add 2 more additional data centers.
How dare you?
This is a shameful display, an absolutely shameful display. And this will spread. We will make sure everyone in this town knows exactly what you guys knew and what you refused to tell them. We will make sure of it. We will make sure of it. And we will make sure this does not happen. This will not happen. There is no redevelopment agreement in place. They are not a designated developer as it currently stands. This is not happening, guys. It's not happening. We refuse to allow this to happen. You cannot sit up here and not tell the public the truth and then get to approve these things. That is not how that's going to work. That's not how it's going to work. And let the record show, the neighboring towns, we're not aware of this either. In fact, we have emails showing, as recently as just a few weeks ago, officials from Roselle Park emailing this borough, requesting specifically, are there plans for additional data centers? And a reply back, avoiding the question, stating nothing in relation to additional data centers. Not a word. Implying that your only knowledge is of the current conversion. Incredibly convenient.
Liars. And the corruption.
Yeah. That's my time. Yeah. You love wasting time. You spent 2.5 hours harassing homeowners over parking spaces. But something that is literally hundreds of times bigger, with hundreds of times more impact to tens of thousands of people, not their block with like 100 people on it, that does not deserve 2.5 hours of scrutiny. Correct? Am I correct in that assessment? It seems I am correct in that assessment. Maybe if the homeowner just came up here with $1 billion and an army of lawyers, it's a damn shame they even needed 2 to begin with.
They worship money.
Well,
They'd have a better luck.
then we'll have another.
I don't worship you.
Thank you. Good night.
Hello. So May 8th at 7:56 p.m. there was an explosion. I spoke to the fire chief about it. He said it was the turbines that they turned on those generators. There's going to be 31 generators at that site, diesel generators. It said they're only testing, and it turns out they need to test them once a month. If you look at Sterling, Virginia, people who watch this at home, Sterling, Virginia, look it up. That's what they told the residents in Sterling, Virginia, that it was just a test to be on for 24 hours. Guess what? It's on a year later, hasn't turned off. Guess what's going to happen in Kenilworth, New Jersey?
Same thing.
The lack of answers. Hello. The same thing. In addition to that, with the fire chief, right? I asked him at the street fair, I said, so what's going on going forward for data centers? When there's a fire, you guys equipped to deal with it. I didn't know there was a volunteer firefighters. You guys are amazing. Thank you for volunteering, but you're not even paid. So in addition to that, the fire chief said, oh, we're doing trainings for that. Okay, cool. You're doing trainings for that. In January of last year, in Roselle Park, there was a fire that took over a whole warehouse. It took over 4 hours to contain with multiple fire departments from various towns. There we go. So with that said, when there's a fire at the data center, is Kenilworth volunteer firefighters going to be prepared? Are the surrounding towns also going to be prepared? It's noted that after the building is up in Kenilworth, that the fire department is going to do a walkthrough. A walkthrough. Right? A walkthrough is not training.
Yeah, when they die,
Correct me if I'm wrong.
but they ask,
other towns to help us.
There has to be other police officers, fire department that is equally as concerned, but they cannot speak up about this because they work for the town. How do you think they feel learning what they just learned from residents who are not paid protesters, who are devoted to this? How do you think they feel? You don't care because they get paid, right? So what about local fire departments? Are you guys going to prompt them on how to be prepared with fires at AI data centers? Keep in mind, people at home, data centers, a 1 megawatt data center and an AI data center are very different. All right, so let's call it what it is, an AI data center, and let's call it really what it is, a surveillance center.
They're not crazy about it. Be all ashamed. Just look at it. Right? It just like bothers me. Like,
Don't show them any respect.
where's the
Don't
soul?
respect these people.
Where's the soul?
They don't respect us.
They won't care if those
You don't
firefighters
respect
go
them.
in there and get sick or killed.
That's where you lose.
We're legionnaires.
Respect them, they win. These are nothing.
No, they don't.
Nothing at all. This is my ass.
Good evening. I'm going to just say this for the record. In reviewing the Oprah, there was mentions of NDA that were signed. So I need to understand about these NDAs and whether any of you have signed those NDAs, because the fact that it's mentioned over and over in the public records, I need to understand who signed those NDAs. So, Mr. Paserno, did you sign an NDA?
Planning board members are not permitted to sign NDAs.
Well, there's an email from a lawyer.
So,
It goes to the mayor.
you know, there's,
You all signed
yeah, the
NDAs?
mayor's on the planning board as well. So there's a lot of contradictions about these NDAs. And I don't understand why there's even a need for anyone to sign an NDA. There's no lawyer tonight, right? We only have engineers and, yes, so what's the purpose of an NDA? What are we not wanting to disclose? Trade secrets, patents, sensitive data? We're a Kenworth's a public entity. Things are transparent. We don't have secret chemicals to hide or anything, or secret patents on how to build or make anything, or even design anything. So I need to understand about NDAs and why anyone would sign an NDA for a project like this.
I don't know, there was no request for NDAs for any of the planning board professionals. None of us signed NDAs, we weren't presented with anything. Applications are made in public and they're heard in public. That's how a planning board operates. A council is totally different.
No council said they didn't.
The council also,
I said, it's a different body, it's a different mechanism.
okay, so for the record, planning board and the town council have all denied signing NDAs, even though they're in the public record documentation. Thank you.
Hi, good evening. So I have a question for all of you, and I would hope you would give me the courtesy, like I sat here for 3 hours and listened to your spiel here. What do you want to leave as your legacy? What do you really want to leave? I mean, all these people are concerned about this, and you all are just basically stone cold faced. I'm talking from the heart, Mr. Paserno, Mr. David, and the rest of you. Attorney, you're just sitting there, it's like you're all in empty seats. There's like nobody there, because these people are asking for answers, okay? These police officers put in 3-4 hours a night right here, just sitting, listening to all of us, listening to 2 hours of the meeting before. You're counting the clock. The mayor was so weak the last meeting, she took that clock and she threw it to the ground. And I'm gonna tell you what else she threw. She threw all of you under the bus, okay? She said the planning board is the one that approved CoreWeave.
They did.
Okay, but where were these
They
people?
can't answer the question.
But where were these
I can't
people
say
here
this anymore.
when you guys approved it? You did what, 2 houses today, whatever? I don't even know, a house and a gazebo. Okay, telling the one lady put up a net. Why should she put up a net at a public park when the park department should be putting up the net for that soccer ball. Okay? I'm sure all of you have beautiful homes, and you like to live comfortably, right? Just like she wants to live comfortably. And you're gonna worry about a 30 by 25 gazebo, okay? That's probably very expensive, that I probably can't even afford, okay? But again, I just wanna know, where do you wanna leave your legacy? Nothing? I mean, I'm asking you, I mean, I just got a question. Mr. David, I know you want to answer, but you're pretty much tied. And I know all of you, most of you, nobody wants to really just speak out. And I get it. You know, you're afraid of about peership and all of that stuff. I get it. You know, but at the end of the day, you got to go down, you got to live, you got to go to sleep at tonight, put your head on the pillow. I hope you sleep comfortably. I mean, I will, but this has always been in the back of my mind, because I got an 18-year-old kid right here that I got to worry about, that are these brain waves. I got a dog at home. She hears plenty times more than I can hear. She's going to hear that hum of a refrigerator that your mayor said. And again, I'm not here to make a mockery of any of you. I just want to know, you know, do you want to be a leader like they taught us in the Army? Do you want to be a leader, or do you want to be a follower? I'll leave you at that tonight. Thank you.
Hi, my name is Sue Vidanzi. I'm from Roselle Park. And I started looking at the map and counting the number of schools which are in a 2-mile range of these data centers. And our high school in Roselle Park is only a half-mile away. Your Harding School is 1.9 miles away. Aldine, Sherman, and Robert Gordon are all within the 2-mile range of this data center. These are my elementary schools in Roselle Park. We also have a middle school next to Robert Gordon, same range. There's a school in Washington, about a mile and 3/4 in Union. And there's Orange Avenue School in Cranford, which I'm sure is between 3/4 of a mile. I want to know what regulations you have, or what the state has told you, or have they told you yet? And why are you making these data centers before you even get the information of how these schools are going, how far a school can be when it's safe from a data center? And then I'm just shocked that I didn't realize you're making more data centers. You haven't even gotten the one done. I'm floored. So can anyone tell me, have you talked to the state? Has the state talked to you about what's safe for a school to be near a data center? What's the plan? Do we have a plan? Are we going forward with, are you talking to CoWeave and the state? I don't understand what you guys are doing. I mean, there's gotta be a plan, but no one's saying anything.
The planning board doesn't operate that way.
What?
The planning board doesn't operate that way, right? We don't.
Okay, but I was at the other meeting and they seemed to think that you guys had all the power.
No, I understand.
So who are you guys going to meet with the other towns in Union County to talk about this? Because what you're doing is affecting all of us, but we don't get any, not that we don't need the money this badly it doesn't make sense. You guys are not gonna have any taxes, but you're not gonna have your health. You're not gonna have your youth.
So, if I may.
Go ahead.
Okay. So the redevelopment agreements, the designations of the redevelopers, those agreements are not done in this form at the planning board. Those are all done at the council, right?
Okay, but they just sent us here.
No, redevelopment agreements to designation. What the planning board does is hear the application, right, for the actual project, right? the bulk variances and things of that nature, right? So that's what we get, and that's what we rule.
And they're not
But you
supposed to
approve it.
approve
You
unless
approve it.
they have an agreement with the redeveloper, and they don't. But they approved.
So,
Yes, they did.
I mean, it just feels like we're in the dark. I have no idea what's going on here.
But I was just trying to answer your question.
They approved the tax.
So what's going forward? What, you know, Roselle Park is asking you questions, and you're not even, replying?
They're not asking questions of the planning board. They're asking questions of the municipal council and the city.
Okay, so the
right?
municipal council
Which
just
is-
shoved them off.
But that's a different entity, right? So I can't answer that question.
Okay,
Right?
so who do we go to get the answers? Are you having meetings with Cranford and
Planning
Westfield?
board does not have those meetings.
Did you inform the town?
And just say it was a state. Instead of planning board pointing fingers at the council and council pointing fingers at planning board, just say it was a state. And you guys are just being blackballed, just say the truth.
Anyone else would rather that? Sir, you already spoke.
Show me in black and white, Mr. Attorney, respectfully. So respectfully, can you show me that in black and white? Show me where it says that I can't speak again.
No, I was asking maybe you would like to have somebody else get up.
Oh, So, I respect you, Mr. Attorney, but it's my time. So, my question again is, where was the planning board, where were the people of the municipality? You guys, again, saw two clients today. Where was the planning board, or where were these people in this room when you guys approved CoreWeave? I'm only asking you the reason, because you're the only one that
There was a
seems to
prior
speak.
approval back in 2025, where that.
So was it closed?
No,
Closed?
that was a public hearing. I was not here at that.
Okay, I understand that.
Right, but there is an approval that occurred in 2025.
But then one that happened in 2026,
The one in
April 28th.
2026 is a subdivision, just the division of the lots.
So is it being-
The projects or the construction or any of those issues.
So this multi-billion-dollar company that bought Kenilworth, basically,
20% of it.
is the public going to be in on that next 3 development phases or 4, whatever it
They
is?
will have to file applications for this board, and similar to the gazebo and the two-family house, there will be a hearing that runs that structure, where they will have to bring their experts, the board's experts, will ask questions, the board is free to go get additional experts if that is required. And the board then gets to ask questions, the public gets to ask specific questions of those experts that testify at that hearing, at that time. What I heard 2 months ago was just a pure subdivision, right? They didn't talk about, they didn't give us anything, that after that was not provided to us, that was part of the application, provided to us, meaning the planning board.
Yes, no, they had that now.
No, because that,
Oh, because it has colors on it.
didn't have.
Thank you for dumbing it down for me, because I did need that a little bit.
No, that's fine.
But my next question is, again, all you heard these clients up here earlier, you had questions, you had answers, okay? Mr., how do you say it, Mazzio? You're nodding your head, so obviously I'm getting through to you. But why aren't you answering these people, just like you answered those two? I mean, yeah, I understand they got to pull permits, pay for stuff. These people, they don't got no skin in the game. Why can't you answer them?
Because
I get it, you seem to have all the answers.
No, I don't
So it's like, no, I'm not mocking you, but
It's my job.
it's like when we're in school, that one kid, there's always that one, that always like, ooh, me, all the time.
But my point to you is, a planning board conducts hearings, right?
Or why can't they answer? Because your mayor pretty much said, The planning board, the planning
You
board.
let him ask those people
I'm just saying,
questions, and he
that's-
went back and forth. He didn't talk all the time.
We listened to 2 other applications. If you would have come a week before and said, hey, before that hearing, I want to ask this board questions about that case, we would have said, you have to wait till the hearing, right? So this board is very cautious because it has to make a decision, not to answer questions, prejudge things that is not.
2 weeks prior to that, I wasn't living here, and I probably wouldn't have bought a house here.
I understand. An application that's not yet pending or before them. So there's a lot of speculative questions that it's not the role of the planning board. It's a specific role, a specific function they play. And it's different than regular municipal council or state or any other level of government. It is quasi-judicial, where we swear people in, where we take hearings, we take testimony, so we treat it as a trial. We cannot answer or comment on those things before the trial began.
But just so you know, a lot of your surrounding communities, they shut it down, man. They shut it down. I'm talking real. They union banded.
This is special.
Yes.
Nothing to
One more thing, I gotta give a shout out to these, time's up, sir. But I gotta give a shout out to these police officers, and these first responders that are really nice. You guys do a hell of a job, man.
So you're saying that there's no more application for any more data centers filed at this point in time?
I'm not aware of an
No
application. There's no
application.
application.
And when they do get filed, or if you're lying to us, because you guys understand, you've all been caught in so many lies between the board and the council going back and forth, we have no trust in you.
We have told you on a number of occasions.
So when they do submit it, and I'm pretty 100% sure they're submitted if they're not already, when will they be posted that we can come to the meeting?
So we have told you a number of times, and we'll reiterate, when an application is.
No, I get that, okay, I get that.
You are-
Okay, so then let me ask you again, so then on your agenda, then, it will be on your, maybe word, I
You asked and
apologize.
answered your own question. Perfect.
Yeah.
It will be on the agenda.
What just so?
Yeah, in fact, you might hear liars, I don't care.
So, it's June already, right?
Right.
If they file tomorrow, say, they file tomorrow, file, it would not be on July, there's no scheduled meeting in August.
Right, so just keep looking for the agenda.
It could be six
Okay.
weeks, right?
All right.
There is a time that when they file, we do what is called a completeness review, right? Where we check to say, okay, we need this, we get a survey, we do whatever. So there's a time period where we ask for more information, or they provide more information, and then it gets scheduled.
Okay.
On the schedule.
Just keep checking the agenda.
That is the best safety.
Okay, right. And please, yeah, and please don't be rude to me, because you got rotten lies, I can't help it. If you were lying in the first place, maybe there's
Is
more
there
stuff.
another person who hasn't spoken yet?
I just have a question based
Sir,
on what you
come on
asked.
up. Now, he might have read. He knows the ending. So the first second, and not the
It's real brief. Real brief. I appreciate the dialogue. I'll be real brief. The question was, what exactly was passed here by Coral in 2025? What, in May of 15, what was that? That was passed.
The approval of the site plan for the data center that's currently under construction.
Thank you. And just a follow-up.
So it's under construction.
Under construction?
Yeah.
There's no finalized
Under
financial.
construction.
But it is, we were told it wasn't by.
Yeah.
Nothing's going on. Nothing's going on. Maybe you show on video.
Was that approval?
I don't know where that approval was at. That's your next one.
I guess that wasn't actually, was that approval, has that passed, been in front of the town council yet?
It doesn't, that type of approval does not go back.
In most towns it does.
No, it doesn't.
In Cranford, I think it
No,
does.
the two approvals the two things we voted on tonight do not go back.
Oh, I'm sorry, in 2025, maybe.
That type of site plan approval does not go back.
Okay. And I don't answer, is anyone willing to answer if that approval was shared with other towns?
I couldn't tell you.
If you you everything you don't know?
That's it, I'm telling you, I can't tell
You can't tell me you know what you don't know.
No, meaning I don't.
Appreciate it. You don't know. Appreciate it.
He's a lawyer.
I just got a comments, no questions. But like, guys, it was getting bad. Like, people online catching your wife gambling. The Aki ball guy that usually sits here, like they call him like he got anger issues. Sorry, yo, chill. And I'm just saying it's getting really bad. Like, you guys can barely speak anymore. Like, you guys was yapping a lot. First, like the first meeting, you guys were talking a lot. Now he's saying you gotta protect y'all. Like, everybody here got receipts. My boy printed out the board. It's getting really hot. Like, everybody got receipts. My girl here, receipts. Renee, receipts. Like, everybody here got receipts. Girls yapping y'all up. Like, I know it's getting tense, but since the first meeting, once again, excuse me. It's hard to even talk to y'all, because it's just like, y'all, I'm telling you, like, evil, right? Evil. Very similar. I feel like, damn, it's tense. Okay, but, you got these people stressing, like, we all stressing, like, the willpower in this room, like, this doesn't happen off of some, like, nitty-gritty crap. Like, this is serious. Like, when you have the youth coming together, like, people of old generations coming together to fight the same issue, like, it means that there's a very clear villain. Like, it's an extremely clear villain. Like, everybody comes together like this. Like, yeah, like, I'm sorry, but y'all are tweaking. Like, y'all gotta go home, really sit with your thoughts. Like, all this government BS, the job BS, like, you was right here with us at one point. You know what I mean? Like, you was somebody in the house, and your mom's might have built a gazebo she shouldn't have built. Like, you know what I mean? Like, we're just saying, like, AI data center, like, come on, if you heard that at the right age of 20, 19, got 3 of them in your backyard. Imagine how your moms, your pops, like, imagine how they would have felt. They would have been fighting the same thing. Oh, hell no, I'm not gonna have this in my backyard. No, they would have been doing the same thing we're doing here. And you know, you guys have all your excuses. I know they're right now. That's why I said only comments. I'm only trying to ask questions. But, like, I'm just saying, like, get it together, please. Like, it's getting, I'm telling you, it's only gonna get worse. I'm not saying it as a threat, but, like, we here, bro. Like, it's hot. It's hot. That's all I'm saying. Thank you and good night.
Motion to close. Made by Mr. O'Brien. All in favor? Aye.